Okay, we're now live and on the record for Monday morning civil docket for June 6, 2022. All right, Mr. Davis, what do you have?
Good morning, Judge. It's number 59 on your docket.
Okay.
And
F 2734-19-9 in the interest of minor children.
yes, ma'am, Judge. It's a SAPSER case. Last week I was hired by the petitioner, Ms. Leticia Guzman, and we're asking if the court could be retained on the docket. We did file an amended petition and we're going forward with the case.
Okay, so the respondent in this matter, has that person been served?
As far as I can tell, no. That would actually be my client's sister. But we are going to get her served and we'll be requesting service this week.
And the sister, where is she? She's the biological mother of the children?
That is correct, Judge. And my client's the maternal aunt, and she's had the child for several years. And as far as I can tell, there's no presumed father, there's no acknowledged father, and there's no established father. So we need to get mom served and proceed from there. And my client's just seeking conservatorship, not termination.
I understand. And has a search already been done with the state to see if anyone has signed an acknowledgement of paternity?
I'm not sure if we've done it, but I have instructed my staff that we're going to need to do that.
Okay.
Bureau of Vitals to get that.
Is the biological mother incarcerated?
I do not believe so. She can be served.
All right. Okay. How much time are you requesting?
I would say if we could get about 45 days, that should give us time to get service done. And if there's issues, and then be back with the court to address those.
Okay, because the child has been in the maternal aunt's possession for over
several years. Right, several years.
Okay.
So it's not.
So the likelihood is that mom is not going to file an answer and this would be a default.
Right, I understand that it's essentially agreed to. We just need to get something, obviously.
Oh, so they have contact.
That's my understanding.
Okay. So they have contact, so then mom would probably sign a waiver?
Either that or sign off on our proposed SAPSER order, just granting her sister conservatorship.
Okay, and it's one child?
Yes, ma'am.
Okay, gotcha. Okay, let me go ahead and see this. Okay, it would be August the 15th.
Okay.
At 9:30.
Alrighty.
Okay, anything else?
That's all I have, Judge. Thank you. May I be excused?
Yes.
Thank you.
Okay, let me see. Thank you. All right, Ms. Orellana, what do you have?
Good morning, Your Honor. I have number 4 on your civil docket. It's a DWAP.
I barely noticed my video was off. 1 week of not doing Zoom and I already lost my touch. All right, what number? I'm sorry.
Number 4, Your Honor.
CL 170613-I, Angel Garcia et al. Versus Jesus de la Rosa and Marta Martinez.
Yes, Judge. Ms. Martinez has been non-suited a few months ago. On this one, the court has been kind enough to reset a few times for me. I've been unable to get my clients to get some time off of work to get their testimony regarding this default judgment. I did speak with them about a week or so ago, and unfortunately, they just don't have permission to take an hour off or even 30 minutes to be here this morning. However, I have submitted documentation in regard to the auto accident that occurred back in 2016. I've also submitted medical records and bills for the treatment that my client sustained as a result of this accident. So I'd like for the court to take judicial notice of those documents. I believe we did file an order.
Okay, before you go on, hold on. Before you go on, what does your client do for a living?
Let me double check, Your Honor, but I think Angel works at a body shop.
So he's not the governor of the state of Texas, not the
No.
president of the United States,
No, Your Honor,
not
no.
the attorney general.
No, ma'am.
Okay, yeah, so he works at a body shop and cannot get an hour off to put some effort into his case. Can
Unfortunately.
you understand? No. And that is not gonna fly here because, and it's not your fault, Ms. Orellana, it's not your fault. Because you can only advocate for your client as much as they want to put an effort into the case.
Sure, Judge, and that's been explained to him, yes. I did, all I can do is ask, and I'm leaving it up to the, to your discretion, Your Honor.
And what about the other plaintiff, Ms. Solis?
On Karina, unfortunately, I've just been unable to get a hold of her. It doesn't sound like there's any communication between both of them. I've sent letters, I've sent phone calls as much as I can, and I just don't get anything back from her.
Okay, so I'm going to give you one opportunity because this is what I would like for you to relay to your client.
Yes, Your Honor.
If they do not show up to prove up a default at the next time, and next time it will be in person, then it will be dropped, okay?
Okay.
And let them know, please let them know that I will put enough on the record to make it, to pretty much cover you and cover me, because they have made no effort to prove up a simple divorce. I mean, a default. I can't even imagine how many of these civil attorneys would love to be able to do that, and your client has no idea. And I understand that sometimes they can, but this is a 2017 case. When did that accident happen?
In 2016, Your Honor.
Okay, so you see, I'm already getting chewed out for criminal cases that are 2016 and older. And I inherited those just the way I inherited these.
Right.
So if they're on me to get rid of those criminal cases, can you imagine also on these? You know what I mean? So
of course,
please let Mr. Garcia know that I'm going to give him one last opportunity, August the 15th at 9:30 a.m. He has almost 8 weeks, more than 8 weeks to make arrangements.
Will do, Your Honor.
He's just let him know that he's putting you in a bad spot. And he can also go back and view this YouTube video.
Yes.
And he'll know you're telling the truth.
Sure, Your Honor. I'll go ahead and relay the message to both of my clients in writing.
Okay, and did you have another case?
That's the only one I have this morning, Your Honor.
Okay, thank you.
Thank you. Have a good day.
You too. Okay, Mr. McCallum, what do you have?
Good morning, Your Honor. I have number 68 on your docket. I believe it is CL 22-1746I Arnulfo Alvarado versus State Farm. It's one of these property damage cases, Your Honor, where we've requested appraisal. The appraisers were unable to agree on the amount of damage, so we're asking the court to appoint an umpire. I believe I did submit a list of potential umpires. If not, I'll have that done by the day's end. I think opposing counsel Avinel Abner is also on the call or on the Zoom. I don't know if he has anything different.
Yes, yes, Your Honor. We have some objections to this application, and the reason why is based on ripeness. I don't know if the court wants to hear it now or later.
So on the application for the appointment, you're objecting the application or objecting to the umpires?
Okay.
Objecting to the timing of the application.
Okay.
Yeah, essentially, the policy allows the appraisers to have 30 days to try and reach an agreement. And our appraiser sent his estimate to the other appraiser on May 4th, and they filed the application 8 days later. And basically, once these applications are filed, it creates a communication breakdown between the appraisers. They're just assuming an umpire will come along and guide the conversation, and they won't even try to reach an agreement. And the problem with that is that it increases the cost of the appraisal. The cost of the umpire are borne by both sides, including the insured, and it slows down the process, and it gets a court involved when it's not necessarily necessary. So I think the appraiser should be given at least 30 days to try and reach an agreement. Our appraiser hasn't even received an estimate from the other appraiser showing that there is a communication breakdown. It's been several weeks since the application was filed, and nothing gets done as soon as the application is filed. They just stop talking to each other.
Okay, Mr. McCallum, do you want to respond?
Your Honor, I filed the application that way. If it doesn't, they don't get it done, we already have something on file. I don't mind if the court, the court would give us a 30-day reset so that we can, give them 60 days to look at it. I don't mind doing that. I just wanted to have something rolling so that I want to get the case done. That's why I do it as soon as possible.
Okay, we'll go ahead and have a status hearing on August the 15th at 9:30. That'll be in person. And then from there, we'll take it, because since we'll be in person, I can have the application there on file. At the same time, we'll take it up.
Thank you, Your Honor. That's all I have before this honorable court, Your Honor. May I be excused?
Yes,
Thank you. Have a great
thank
day.
you. Mr. Adler?
That's it, Your Honor. If there is an in-person hearing, I have one request, and that is that Mr. McAllen files his umpire recommendations before the hearing to give the other side an opportunity to voice any objections, if any. What ends up typically happening is we have a
Hold on,
hearing.
I
I'll do
understood
it.
that you did already.
I usually do, Your Honor. It should be on there, but if not, I'll definitely do it.
Okay,
And I'll provide him a copy.
anything else?
That's it, Your Honor.
All right, thank you. Y'all have a good day.
Thank you very much.
Okay, Mr. McLaughlin, what do you have, sir?
Yes, Your Honor. Number 48 on your docket, CL 196537, Citibank versus Rangel. It's a motion for summary judgment that's been filed with the court.
Okay, Citibank versus Tomás Rangel. And the motion for summary judgment, did you e-file it already?
Yes, Your Honor.
Okay, hold on. Ms. Rivera, can you verify the motion for summary judgment and the order setting hearing, please?
Judge, the order setting hearing, I don't see it. Give me one quick second, Your Honor.
Okay. It's because I can't get into my Odyssey. I changed it. I changed some password and I didn't write it down. So
Okay.
lesson learned.
Okay, Judge, there is an order setting hearing for an MSJ, Your Honor, but it is not set for this morning. The only thing that I have here is that the DWAP was set. Yes, ma'am.
Okay. All right. So Mr. McLaughlin, are you saying that you want to proceed with the motion for summary judgment? Not today, but in general.
Yes, we do.
Okay. All right. So that order setting hearing, I'll have it requested from the clerk so that we can have a date put on that. But just so you know, that will be in person. So I don't know if your firm would be sending you down here or if you'll be getting local counsel.
Okay, thank you, Your Honor.
Okay. And then anything else?
No, Your Honor.
Okay. Thanks a lot. Hey, Mr. McLaughlin, where are you located?
I'm in Galveston today.
Oh, okay. Well, we're all the way down here in South Texas. You should tell them to, after you've been covering the docket for 18 months, you deserve to be graced with our presence.
I seriously need to come down there. Yes, I do.
Yeah. All right. You take care, sir.
Thank you, Your Honor.
All right. Okay, Mr. Kosofsky, good morning, sir. What do you have? Oh, you're on mute.
We'll start again. Good morning, Judge. How are you?
Good.
Great,
Okay.
great. Good to see you. It's been a couple of months now.
Yes.
Can I get, I'm on number 965. It's CL 220334-I. It's a friendly suit.
Okay. Don't tell me can I get, because my mind right away goes to a number 1 with cheese, extra pickles, extra mayonnaise.
As soon as I said that, I started drooling just because I was thinking the same thing.
It's just like, it just comes to me. All right. Okay. Anahi, Anahi Espinosa, Espinoza versus Eliseo, Eliseo, Marte, Marte, or Marty Flores. And Mr. Garcia, you're here.
Good morning, Your Honor. Yes, Rogelio Garcia representing Mr. Liceo Marte Flores.
Okay, and who is the ad litem?
Miss Edna Cedillo, Judge.
Oh, Miss Edna is in person there somewhere.
She stepped out, Your Honor.
She is not in person anymore.
Let me send her a quick message, Your Honor.
Okay, Mr. Kosofsky, Miss Cedillo has some in-person hearings there. She had popped in and she was ready So Miss Rivera is gonna send her a text to come back. So I'll recall you as soon as she shows up in the courtroom.
Very good, Judge.
All right, thank you.
Your Honor, if I may, excuse me, Judge, we have a really quick announcement on another matter that Edna Cedillo and I are on
Okay,
involving Cesar Aguilar. It's number 64 on your docket.
okay, CL 21-3289-I, Monica, Monica, Estela, Estella, Trevino versus Geico.
That's correct, Judge. Rogelio Garcia representing Geico. On Friday, Mr. Aguilar's office contacted us that he had a conflict and he was not going to be able to make this hearing. So a Rule 11 was circulated, and I believe it was filed this morning. So I just want to advise the court that Mr. Aguilar has asked for a reset and even filed a motion to reset this hearing.
Okay, Ms. Rivera, do you see that an order resetting hearing was filed with that Rule 11?
Judge, if I may,
I'm sorry?
may I please let the court know that Mr. Aguilar's office did call this morning that they were filing the Rule 11. They were missing a signature, but they finally were able to get it. Right before we logged in, I checked on the case and it was still not showing up on Odyssey that they had filed their Rule 11 and their order resetting.
Both have been accepted, Your Honor.
Okay. Both the order resetting hearing and the Rule 11.
Correct, Your Honor.
Okie dokie. Okay, so then we'll go ahead and get that set and sent out to you all, Mr. Garcia. But it probably now won't be until, unless, are you all already ready on this one?
Yes, yes, Your Honor, we are.
Oh, okay, then we'll try to get it reset so I can hear you before the end of the month.
Thank you, Judge. Appreciate it. That's all I have on that particular matter, and I'll stand by on the other case that was called earlier. Thank you.
Okay. All right, as soon as she gets in, we'll go ahead and get to you.
Thank you, Judge.
Okay, Ms. Matter, what do you have?
Good morning, Your Honor. I have number 72 on your docket, Geico v. Jennifer Aguilera. It's a motion for default judgment.
Okay, CL 21-3255-I, Geico County Mutual Insurance versus Milton Aguilar and Jennifer Lee Aguilar. And if someone on if Ms. Rivera or Ms. Castañeda, you can check that service was properly done.
1 second, Judge.
Sure.
Judge, for Miss Jennifer Aguilar and Milton Aguilar. Well, Miss Jennifer was served. Second, Judge. There is an affidavit, Your Honor.
Okay, on both of them?
Miss Milton was non-suited, Your Honor.
Oh.
But Miss Jennifer was properly served and it was returned, Your Honor.
Okay, can you give me that date of service and date of return, please?
The date of service, Your Honor, is October the 2nd, 2021,
Okay,
and it was returned. Actually, Judge.
I show it being stamped by the court on October 12th, if that's what you're asking.
I'm just I don't see the return, Judge. It was filed, but the sheriff's department didn't sign off on or the process server did not sign off on the return, Judge.
so, okay, so Ms. Matter, do you see that the citation and, the return has been on file with the court for the required amount of time?
So
Because
at the top right of the return of service, it notes electronically submitted on October 12th of 21.
That's the file date, Your Honor.
for the When
Yes.
the citation,
Let me, if you'd like to check and share my screen.
hold on. What I'm saying is because if it was e-filed on October 12th after it's been served, then that's the return of, then it should be the return of service. That's when they did the return of service. So let me see.
It's
Right
filed,
here.
Your Honor, but it's blank.
Oh, that's the one I have that definitely has a signature on it. From Geraldine Castaneda.
Hmm.
Your Honor, it should be part of the exhibits that were attached to our motion for default.
Okay,
judgment.
check their exhibits, please.
1 second, Judge.
Thank you.
Thank you.
Okay, so I'm looking at the return of service and on the affidavit said, okay, the person received the citation on September 23rd and that she was served on October 2nd. And then the bottom part where it says defendant served, that's not filled out. Do you see it? If you'll go back to your return of service, which if it's part of your exhibits, you'll see.
It's all in the same filing, Your Honor.
Mine doesn't show any blanks. I must be looking at a different document. So let me look at the actual return of service that was filed with the court as opposed to just the one that I have in my exhibits.
Okay.
I see. So it looks like our service processor didn't fill out your paperwork. They just submitted their own affidavit. Is that what you're referring to?
They can submit their own affidavit, but I understood that for it to be a proper service of return on the bottom, they would have, I mean, hold on. Let me look at it again because they sent me.
Yeah, I just don't know if we're looking at the same document, but I do see where
Was that document notarized, the return of service?
No, it does not look like it was.
Okay, because if they did an affidavit, in order for it, well, what I know is that they would need to have been notarized in order to have been properly done. Unless you have some, of some other way, or if this is proper, you can put something on the record, but other than that, they would need to fill that out again and have it notarized. If they did an affidavit, it should have a signature line for them.
So all I see is that they did sign it, but it is a return of service. It doesn't note it as a return of service. It doesn't have anywhere for notarization. I'm sure we're looking at the same document, but where they've just, Geraldine Castaneda filled out this return of service and signed it.
Okay. So I'll give you an opportunity to have her correct that. And then it does need to be on file for at least 10 days.
Okay.
So as of right now, I'll do it for August the 15th because you will have to also submit an order resetting hearing.
Okay.
And then that way that person has enough time for it to be, for them to have notice of the hearing. Give me one moment.
Okay.
Okay, I had to remind my daughter that I was on Zoom. Okay.
Yeah, this is, I can tell you that, Your Honor, this is the first time I've ever had this issue, and we have had the same service processor throughout all of COVID, even in front of this court. And I have never submitted any different affidavit or any different return of service. But of course, we'll go with whatever the court prefers. But this isn't anything new on my end.
Well, hold up. So you're saying that in the other cases that I had accepted the return of service without a notary, without it being notarized?
So I can say that this exact form has been submitted, yes,
No,
throughout.
I don't have a problem with the form. The form is fine. What I have an issue with is that it's not notarized nor the info. I mean, I know that the information, it's not so much that it's blank, because the information that is there, it's in the body of the affidavit, which is fine.
Mhm.
But if it's an affidavit with the return of service, it should be notarized, shouldn't it?
Your Honor, may I speak as a friend of the court?
Yes, go ahead.
Because I pulled it up while you're talking about this issue.
Okay.
I apologize, but
Can
107.
you be the staff attorney then?
I can be, Your Honor. I'm very, very cheap, not much. That rule says under 107 return of service, it says the officer or authorized person who serves or attempts to serve a citation must sign the return. And then it says, if the return is signed by a person other than the sheriff or constable or the clerk of the court, the return must be either verified or be signed under penalty of perjury. But nowhere in that rule does it say that it must be sworn under oath by a notary. I'm sorry.
But if it's verified, wouldn't that be, I don't know, Mr. Kosofsky? Next, tell me, educate
Judge,
me.
I agree with Mr. Garza's interpretation. If it's a verification, certainly is going to be fine. That would have a notary involved. But there are rules that state that you can sign something under penalties of perjury, which the state has apparently approved of through some of the legislative changes recently.
Okay, so but does that affidavit have to state that they signed it under penalty and perjury? Does that affidavit state that?
Yes, it does, Your Honor.
Okay. Well,
Very good.
there you go. That's a free CLE. Everybody gets 0.25 hours.
I'm sorry to putting my spoon in the studio.
No, I'm glad you did, because you know, there are changes, and I mean, things come up, and you know, you want to make sure that you put all of that on the record. And you know, I'm not in the habit of just granting things to grant them. You know what I mean? I'd rather be told later on, hey, you were too careful. You could have granted it at that time, but protect the integrity of the case. You know what I mean? Okay, well, in light of that, all right, so then everything was proper. So I'll go ahead. I'll take judicial notice of all the documents in the court's file, specifically the return of service that Ms. Aguilar was properly served. Mr. Aguilar was non-suited. And go ahead. You can go ahead and put your evidence on the record.
Thank you, Your Honor. Now I have to get back to my evidence. I had a lot of documents open. Okay. So as noted, Ms. Aguilar was served on October 2nd, 2021. As of today, we don't have any answer on file from Jennifer Aguilar. This case is based on an underlying subrogation claim that Geico has from their insured's vehicle being damaged by a motor vehicle accident involving Ms. Aguilar. The damages were $12,102.36. So Geico is asking that a default judgment be granted in that amount, with the amount of $500 in attorney's fees based on $250 an hour to prepare this case and to attend this hearing and to prepare the motions for this hearing, court costs, and interest in the amount of 5%.
Okay, the court is further granting the relief as requested and testified to on the record. And that has also been e-filed. Is that correct? Your order's been e-filed?
Yes, Your Honor, you should have a copy of my order.
Okay, perfect. I'll have that sent up to my queue, and I'll go ahead and sign off on it. Anything
Okay.
else?
No, nothing else for your court this morning, Your Honor.
Okay, thank you.
If I may, I'd like to thank co-counsel for their effort.
I know, there you go. Thank you very much, gentlemen, for your assistance.
I'll send him my bill, Your Honor.
Okay, yeah,
Okay.
go ahead. I'll let Geico know.
Yeah, right. And if you have Geico insurance, you can just tell them, go ahead and pay my premium for the rest of the year, right? All right, thank
Okay.
you. Good to see you.
You as well, may I be excused?
Yes.
Thank you.
All right, Miss Ivana, did Miss Cedillo make it back?
No, Judge, she didn't, and I did send her a message. But she hasn't
Okay.
responded to me.
Okay, no problem. Okay, Mr. Guajardo or Miss Guajardo, I don't know who that, it's an A, so I don't know.
Yes, hi, good morning. This is April Guajardo speaking.
Okay,
I would be representing myself, would be number 1. And
All right.
the case number is, let me see.
CL 180030-I Portfolio Recovery versus April Guajardo. Do we have anybody here on behalf of Portfolio Recovery?
No, I don't believe so. It doesn't look like they're here. I was gonna go ahead and ask to speak for myself.
Sure. Well,
Okay,
you're not gonna have to say much. It's a
Good.
bench
Oh.
trial.
I apologize, Your Honor. John Kettler for plaintiff. I had advised Ms. Rivera I needed to briefly hop off. Again,
Oh.
Many apologies to you and Ms. Gallardo.
Okay, so Mr. Kettler, you're here on that case?
Yes, ma'am.
Okay, so Ms. Guajardo, plaintiff's counsel is present with respect to this case. So have you had an opportunity to speak to them to see if you can come up with an agreement?
I have not, but I was wanting to ask the courts for a motion to dismiss my charges on this case. This was a credit card that had been used back in 2014. And I know that I did try to close it several months, but the Walmart credit card told me that I needed to pay off the credit card before it was closed.
Mhm.
But I ended up going all 2015, making late payments. So I was getting interest charges and late fees racked up throughout that year. So I just wanted to see if there would be a way for me to ask to dismiss these charges just because I hadn't made any payments since 2015.
Yeah, well, it doesn't work that way, or else we'd all stop making our payments so that they can get dismissed and closed off, unfortunately. So you can ask for it. First, it has to be done in writing, but I will tell you that you're not going to have grounds to have it dismissed. But if you make payments throughout that time, you first need to make sure that they gave you credit for those payments so that you can make sure that the right balance that they claim you owe is also more or less what you think you owe. And then because I understand that you were probably in a situation that you couldn't pay, but unfortunately just not being able to pay will not make it go away. You know what I mean?
No,
So
definitely.
I can't dismiss it. Well, I mean, I guess I could dismiss it, but I would not have legal grounds to dismiss it, is what I mean. So what I can do is give you an opportunity to speak to them to see if maybe you can come up with a payment plan. Are you working now?
Yes, I'm working.
Okay. So, Mr. Kettler, is there a contact info that Ms. Guajardo can reach out to you?
Your Honor, I do have a contact number for the plaintiff's firm, specifically the managing attorney there. That way, Ms. Gallardo can get a hold of her or someone who's a direct attorney at the office and negotiate settlement on the balance. Ms. Gallardo,
Yes.
Your Honor, is it all right if I provide that phone number?
Yes.
And Your Honor, it may be, Ms. Gallardo, do you have access to the chat?
Yes, I do.
Okay. Your Honor, it may be easiest for me to provide that contact information to the chat because I have a numerous amount of cases with you today. And so anybody else who may need to reference that might want to entertain settlement, they'll be able to see that and have some point of contact that they can reach so I can avoid repeating it again.
Okay. You can go ahead and put it on the chat, but then I'm going to have to put it on the record anyway. So it's probably best. Okay, so here on the chat, it says that for you to contact Megan, Megan, Hale, Hale. You can get the information off the chat, but I do need to put it on the record. Her phone number is 262-796-7890. Her email is mhale@rsieh.com.
Okay.
And it's there. Okay, so I'll give you an opportunity to discuss that with them, and then we'll go ahead and come back on August the 15th at 9:30.
Your
And
Honor,
Ms. Wahab, can you put your email on the record, please?
Sure. Did you want me to put it in the chat or just say it?
You need to just go ahead and say it. It's fine.
Okay, sure. It's pchacco44@yahoo.com.
pchacco44@yahoo.com.
Yes.
Okay, just so you know that will be in person, okay?
And you said for August 13th?
15th. It's a Monday.
August 15th. Okay, so say if this was taken care of by then, would we be going back?
If this is taken care of by then, as long as you have a settlement agreement on file for me to sign and that both of you all have signed, you don't have to come that day.
Oh, okay. All righty.
Okay?
Thank you.
All right. Thank you. Have a good day. Mr.
You too.
Killer, I'll take you up shortly, probably at the end, since you have the rest of those cases. If you need to do something else, don't worry about it. I'll wait for you.
Understood, Judge.
All right. Thank you. Okay, Mr. Garza, what do you have? Okay, you're on mute.
That was a lot to say, Judge. I'm on CL 213663I, Your Honor.
Okay, what number?
58 on Your Honor's docket.
Okay. Esponjas, ESPONJAS Development versus Adan Guerrero.
This is a appeal from JP Court on an eviction, Judge. The JP granted eviction. The defendant appealed. The date that it was appealed was November 1st, 2020. I'm sorry, 2021. The time to perfect an appeal is 5 days after the judgment from the lower court is signed pursuant to Rule of Civil Procedure 510.9. The bond was set as $5,000. The bond was never filed, Judge. Therefore, the appeal was not perfected, and this court has no jurisdiction to continue.
Okay.
We're asking the court to dismiss it.
Is anybody here from Juan Guerra's office? His office?
I haven't seen him, Judge. I will tell the court that I called 4 different occasions, and I never got a call back.
Okay, Adan Guerrero. Okay, name being called out 3 times, no response. And in light of the arguments, the court is going to go ahead and sign the order on the motion to dismiss. I'll ask that to be forwarded to my queue.
Thank you, Judge.
Okay, thank you. Anything else?
That's all I have, unless Your Honor wants me to stay for the end of the docket to advise.
You are welcome to do that.
Thank you, Judge. Maybe excuse.
You certainly may. Okay. Now, Miss, is it Apia?
Yes, Your Honor. Good morning. How are you doing today?
Good morning. Okay, what number?
Number 69, Your Honor.
Okay, thank you.
And this is just a request for continuance so that plaintiff can file a dispositive motion with the court, Your Honor.
Okay, CL 193902-I, Unifund versus Claudia Garza. And is Ms. Garza making an appearance today?
No, not that I'm aware of.
So did they receive notice of the order setting hearing for the default judgment?
I cannot verify that. I'm not sure, Your Honor.
Okay, Ms. Rivera, can you please look that up for me?
1 second.
Thank you.
No.
Judge, if I may,
Yes.
on the order resetting, it was mailed to Ms. Garza.
Okay, so she did have notice of today's hearing?
Yes, ma'am.
And when did that notice go out?
It was signed it was filed May the 9th.
Okay, so Miss, okay, you said it's
Appiah?
Appiah?
Yes, Your Honor.
Okay, Miss Appiah, she received proper notice. You still want to give her an opportunity to file a dispositive motion?
Well, then we can move forward with the default then.
Okay.
They just
Alright.
did not include that in the information they gave me.
Oh, so okay, I get it. They didn't give you a complete packet?
Yeah, so I wasn't
Okay.
aware of that.
All right, then go ahead and file an order reset. I'm not gonna put you in that position, so go ahead and file an order resetting hearing. But it will be
Okay.
August the 15th at 9:30, and somebody will need to be in person.
It's for the default. So file an order resetting hearing for the default to get
Correct.
the default granted. Okay. Thank you, Your Honor. We'll do that.
Okay, anything else?
You said it's August 15th?
Yes, at 9:30 in person.
Okay, thank you.
Thank you.
Bye-bye.
Okay. Mr. Ramirez, what do you have?
Morning, Your Honor. Brian Ramirez on behalf of Los Venados HOA on number 71 on your docket. It's a motion for default judgment.
CL 210012-I Los Venados VENADOS Property Owners Association versus Armando Bautista and Susana Bautista.
Correct. It's for an amount of nearly $25,000. This is dating back to the end of 2019, Your Honor. We asked the court to take judgment and we want to be done with this. We've served them properly by publication, and I believe that their attorney ad litem, Ms. Gonzalez, is here on their behalf.
Okay, Ms. Gonzalez?
Good morning, Judge. I apologize. I'm at first day summer camp today. Judge, on this case, I was appointed the attorney ad litem for the respondents. However, until today, I had not received anything from opposing counsel on this. I went back and checked it. It looks like I was appointed back in November of 2021, and then the parties were subsequently served in January of this year. However, as I advised, I didn't receive anything. I think they were also ordered to pay attorney's fees, and that wasn't done. My assumption, however, erroneously, was that they were not moving forward with this. But Judge, if they are going to go forward, I just need time to reach out to the respondents. There is a certificate of last known address, which indicates there is no address known, but then they served them with two specific addresses in the citation. So I need to go back and check those two addresses. Really what I'm asking for, Judge, is just a couple more weeks, make sure I do my due diligence as their ad litem, and then come back before the court if I'm not able to contact them.
Okay, so how much time are you requesting?
I would say 30 days, Judge. That gives me time to locate them, file an answer, and if they are, I guess they can't be found, then they can proceed with their default.
Okay, all right. Then I'll go ahead and do that, but the earliest that I have is August the 15th.
Understood, Judge.
Okay, and that'll be at 9:30.
Yes, ma'am.
Okay, anything else? Mr. Ramirez, anything else?
Nothing from me, Your Honor. Obviously, we would prefer maybe 2 weeks instead of a month, but if the court believes that a month is proper, then we'll accept that.
Well, yes, because that's the date I gave, so I do believe it's proper. So, okay, we'll see y'all on that date then.
Yes, ma'am. Thank you, Your Honor.
Thank you. Y'all take care. Okay, any word on Miss Cedillo? Okay. Andrew Smith? Andrew Smith?
Yes, Your Honor. Good morning.
Okay. What is the case?
I'm here on number 73.
Okay. CL 214202-I Discover Bank versus Aaron Diaz. Aaron Diaz, Aaron Diaz. Anybody here by that name? Okay, Mr. Smith, you want to proceed?
Yes, ma'am. On our motion for default judgments.
Okay.
Actually, Your Honor, hang on. I apologize.
It's okay.
He would
It's
not like to
Monday.
proceed. I apologize, Your Honor. We actually, it looks like we settled last week. So I would request a.
You already started your Monday off great because you get to be with us, and then now look, you didn't even have to be here. And
Yeah.
Okay.
Well, I was also in Judge Flores' court as well as yours this morning, so I'm all over the place.
But
Your Honor.
So it's settled?
I apologize. I'd like to. Yes, Your Honor. I'd like to pass on this. We should be filing settlement documents within the coming days.
Okay.
We'll
go ahead and
I'd
give
just like
you.
to pass on this.
All right, that's fine. Anybody's okay? Just random thoughts of a Monday morning. So like when Mr. Kosofsky said, or somebody said number one or whatever, then about the Waterberg order. Anybody that says I'd like to, and then the first thing that pops into my head is buy a vowel. Okay, I'll set a tickler, or I'll have them set a tickler for the 24th, June 24th, just to make sure everything's in by then.
Yes, Your Honor.
You think that's enough time?
Your Honor, I showed that we reached the settlement agreement on the 26th of May, but I don't see where we've actually sent out our settlement documents yet. If I could get sometime in July, I'd appreciate it. I just don't want to come back in a couple weeks and tell you, well, we still haven't gotten it done.
Okay, well, you won't be coming back. A tickler is just a court's reminder. My staff reviews them on Fridays. And then they'll call you very nicely and say, get it in by this time or else you'll have to show up. And in a real nice voice too. They'll say
Sure, Your Honor. All right, then June 24th is fine with me.
Okay, so they'll check with you on June the 24th to make sure.
All right, thank you very much, Your Honor. That's all the business I have before Your Honorable Court. May I please be excused?
You certainly may.
Thank you.
All right, thanks. Ms. Fajardo, you are excused. You can log off at any time.
Okay, yes, ma'am. I had just one question before I had left. I know that I had double checked the paperwork and I was just confused on why the attorney's name was a different name than the person that came today. Because on the paperwork, it said that it would be with Jessica.
Yeah, it doesn't have to be
say
Jessica.
her last name.
The firm has a right to have anybody represent them on this day. So you just need a point of contact, which they gave you, which was Ms. Hale.
Oh, okay. Okay, well, I wanted to confirm it.
Well, that's fine. Okay, Ms. Fajardo, so go ahead. You have the contact information for Ms. Hale and go ahead and reach out to her and see if y'all can reach a settlement.
Okay, then. Thank you.
All right. Thank you. You have a good day.
You too. Bye-bye.
Okay. All right, Mr. Guerrero, what do you have?
I have number 61 on the court's docket, Judge.
61, okay.
Yes, Alexi Ramos. That case was resolved. The property was refinanced, and so we don't have any opposition to it being dismissed.
But is there an order, or you're just not going to proceed with the?
Well, we filed a notice of non-suit. I am not too sure if it's made its way up the queue, and I can double check to see if there was an order attached.
It has, Judge.
Okay, perfect. All right, so that's already been taken care of then, Mr. Guerrero.
Thank you so much, Judge. May I be excused?
Yes.
You have a great day.
You too. Okay, Mr. Orozco, what do you have?
Good morning, Your Honor. I am on number 44 on your civil docket. That is Jose Claudia Renteria, and that's CL 195753I. I don't know if opposing counsel or anyone is made an appearance here today.
Judge, if I may?
Go ahead.
Your Honor, the court's going to reset this one to August the 29th. In reviewing the cases, Judge, this one did not receive proper notice.
Okay, so it'll be August the 29th at 9:30.
Thank you, Judge.
Okay.
May I be excused?
Yes.
Stay safe, Judge.
Okay, likewise. All right. I have somebody, Mr. Gomez, what do you have?
Your Honor, good morning. I have number 62 on the court's docket, F 3869-20-9, in the interest of Joseph Hernandez.
Okay, and what is the announcement?
This is a grandparent access petition. I had filed a petition. I served the parties. I sent out discovery. Discovery was not answered, and then their counsel withdrew from the case, and the court granted the withdrawal before I could object to his withdrawal without having answered the discovery. So we're at an impasse right now because the other parties have opposing parties have no counsel at the present time.
Okay, what's the name of the respondent?
The respondent is Your Honor, I'm sorry, I just have it, I don't have the name of the respondent at hand.
And what is your client's name?
German Hernandez, I'm sorry, German Hernandez.
And do you have contact information for the respondent, or is it just?
We served them, so they were served, they are in Beaumont, and that's another difficulty in this case. They are living in Beaumont. She moved from the Valley to Beaumont after hooking up with a registered sex offender, and the concern the grandparents have is for the children is that they are now living with a registered sex offender.
Okay, so my court notes say that on the day of the withdrawal, you had appeared, but Mr. Contreras didn't appear due to being on medical leave. And you did state that you were unopposed to his withdrawal, so I granted it.
Okay.
And so the only thing that I can say is that just file for a final hearing. I can give you a final hearing date now so that you can do an order setting final hearing. And they don't come down for that hearing.
I would like to see if I can get responses to my discovery. So I'd like to file a motion to compel if the court would allow me.
But I mean, isn't it your client that wants the kids back, or what?
We want grandparent access. We don't necessarily want to take the children. We want to have contact with the children and make sure that they're okay because they are with a registered sex offender, and we have no way of verifying that their well-being, given that there's no contact between the daughter and the grandparents now.
Okay, go ahead and file a motion to compel. And then we'll go ahead. I'm going to set this for status on August the 15th at 9:30, and go ahead and get that, do your motion to compel, and you can have it set for the same day.
Very well. Thank you very much. Much appreciated, Your Honor. Have a good day.
Okay, thank you.
May I be excused?
Yes.
Thank you.
Okay. Miss Laura, it says Laura's iPad.
Yes, Your Honor, Laura Strain.
What number?
Your Honor, I don't have your list of cases, so I have the cause number, but I don't know where they fall on your docket. I have two cases. They are both TD Auto Finance LLC. One is CL-18-5521-H, TD Auto Finance versus Ruben Benavides.
Okay, it's the docket is attached to the email that has the link. Okay, I found it, number 66. Okay, and it says that it's approved of. Did you all have an agreement?
Well, Your Honor, I think I've just realized I have this as a default judgment. I don't have an attorney on file, or nor has an answer been filed.
Okay, Ms. Rivera is going to check to see why it was put as a approve of.
Judge, it said as approve of because that is what the plaintiff's counsel filed.
That is what we filed. That's what we asked for because we have no answer on file and we have a default judgment pending before the court.
Oh, so, okay, so we don't do that down here. As far our filings, if you want to default or take a default on somebody, you file a motion for default judgment, set forth what the relief is that you're asking for, like principal, interest, attorney.
Yes, ma'am. We filed that on March 15th, 2019.
Okay, so that's, you called it a motion for default judgment?
Yeah, well.
Your Honor, if I may?
Go ahead.
There is a motion for default judgment, Your Honor. However, the order setting hearing does not state what was being said. However, the court did send it due to the fact that it is hard to get a hold of plaintiff's counsel to have the correct order setting hearing, Your Honor.
Okay, oh, that's what it was. Okay. All right, so on your order setting hearing, hold on, I've been having IT work on this. Let me see if it worked. No, it didn't. Okay, can you pull up their order setting hearing?
Yes, Judge. The order setting hearing, Judge, it's filed March the 8th, 2022. And 1 second, Judge.
Okay. So on your order setting hearing, what you put was that you wanted it to be heard as a plaintiff's request for prove up. And I understand what you mean now in speaking to you. And but that's not, it has to be an order setting hearing that says that is set for your motion for default judgment. And the staff, my staff tried to get a hold of somebody, but that was not successful. So, and I understand that it's like the lottery in there. So with these cases, but with this plaintiff, but if you can give me, well, now that you know, you can pass on that information. So on that order setting hearing for your default judgment, it will be on August the 15th at 9:30.
In person?
Yes, ma'am.
Okay, thank you.
Okay, anything else?
I have
you have another case, right? Which one?
And probably the same thing, Your Honor. The cause number is CL-19-2236-I, TD Auto Finance versus Matsuki Goto.
Number 67, Judge.
Okay, and that's MUTSUKIGOTO. All right, yes, it is the same thing. So
Yes,
you
sir.
can also do August the 15th at 9:30.
Thank you, Your Honor.
Okay, anything else?
Nothing else, ma'am. Am I excused?
Yes.
Thank you.
Okay, any sign of Miss Cedillo anywhere?
No, Judge.
Okay. Anaí Espinosa?
Yes. Judge, she's my client, ready to do the.
Oh, she's ready to do, yeah.
Yes.
Okay, we're just waiting, Miss Espinosa.
Okay.
I said, that name sounds familiar. I think I already called it out, but okay. All right, Mr. Villalobos, what do you have, sir?
Good morning, Judge. I'm sorry. I'm over in San Antonio. Your Honor, I've got an emergency motion to modify a child-parent relationship with Mr. Patrick Sanchez, who's on screen.
Okay, Mr. Sanchez, can you hear me?
Yes.
Okay, what number is this?
Number 75, Judge.
Oh, okay, there you go. Okay, and that's in the interest of a minor child, F1482-21-9.
It would just be her, ma'am. You would have to take a seat.
Okay,
You would have to take a
so
seat.
go ahead, Mr. Sanchez is the father?
That is correct, Your Honor. And I'm not sure if the respondent has ever appeared. Is
So
she
Mr.
present? I
Sanchez
don't know.
Mr. Sanchez is your client.
That is correct, Your Honor.
Okay, and
And
what
I'm
is
not, we
the,
served the respondent. I'm not sure if she's made an appearance. She never filed a written appearance. I
what
don't know
is
if
the
she's in court.
respondent's, hold up. What's the respondent's name?
Your
Mr.
Honor,
Sanchez, what's the
Brianna,
lady's name?
Hold on, what, Ms. Rivera?
Brianna Iracheta, Judge, she's on screen, Your Honor.
Okay. Oh, is that her from the courtroom?
Yes, ma'am.
Okay, ma'am, please spell your first name
Brianna.
and your last name.
Yracheta.
ETA?
Yes.
Okay, you're gonna please remove your sunglasses off the top of your head for me.
Right.
Okay, so what is the situation going on right now?
Judge, apparently it's going to be a contested hearing. I'm just advising the court of that, so you can decide how you're going to run your docket.
Okay.
Mr. Sanchez is seeking to change the managing conservatorship of the child based on some events that he believes endangers her mental well-being, or perhaps physical well-being.
Okay, so is there, who has, okay, physical custody is right now in mom's care, is that correct?
That's correct, John. Yes,
Okay.
ma'am.
So is there an order to that effect?
Yeah, there is, Your Honor.
Okay, so there's an Office of the Attorney General order or between a previous divorce or what is it?
It was a prior divorce, Your Honor. No, I'm sorry, I may be mistaken, but I'm sure the AG was involved in it. But that is a present standing order right now.
Okay. So, and how many children are there? Just one?
Yes.
One, Your Honor.
And what is the child's age?
She's 9.
All right. But do you have a motion for temporary orders on file?
Yes, Your Honor, we filed an emergency motion for temporary orders.
Okay, because
And,
that's not what I have. Hold on.
Okay.
That's not what I have here. What I have is that it's already set for an emergency motion to modify, like for a final hearing.
Okay, yes, Your Honor. I apologize, I misspoke. Yes, it is scheduled for that, Judge. That's what we filed, actually, Judge. No one's ever filed a motion for temporary orders, and we filed an emergency motion to modify. So that being the case, we didn't file a temporary order. We just filed an emergency motion to modify.
Okay, but it's not right for a final on a motion to modify for that, because then that would mean that everything's already completed on this case, which it sounds like you're just starting on it.
That is correct, Your Honor, but I guess that since it's an emergency motion, typically the procedure we've always followed in the past, at least I have, is that it didn't take the same, under the emergency circumstance under the code. I mean, a change can be made if we make the requisite elements.
Yes.
It doesn't take
Under
the
a
same
temporary
force as
order,
typical.
like, okay, so a motion to, if you have an emergency situation, like in this
Yes.
case right now, then it would be a motion, an emergency motion for the modification, but with temporary orders, so that if it's proven that there is a danger for the child in order to change conservatorship, it can be done right away.
Yes, ma'am.
So I'm assuming that's what you're going to want a hearing on then.
That is correct, Your Honor. And I understand it's her first appearance, so if the court needs to provide her time, I understand that too.
No, I know. And just so Mr. Sanchez knows also, all contested hearings right now and from now on, everything is in person. So I'm going to ask Ms. Iracheta, are you going to be having an attorney represent you?
No.
So you will continue to represent yourself?
Yes, ma'am.
Okay, so I do need an email address for you since Mr. Villalobos will need to deal with you as a pro se.
MUA.
I'm sorry, I can't hear you. What?
MUA DEEP 9 @gmail.com.
Ms. Rivera, can you repeat that? Because she's too far away from your microphone. I just got MUA.
DEEP9@gmail.com.
Okay, and a phone number, ma'am?
956. 908-9496.
Okay, do you have anything in your previous order saying that he cannot have your address?
I just recently moved. I just got a new address.
Did you notify him of that address when you moved?
No, not yet. I was gonna update the court first.
Okay, you update the court and him simultaneously. It's required by the statute.
And
What
my
is your new address?
6806 Fernie Drive.
FERNIE?
Yes.
What city?
Edinburgh, Texas.
The zip?
78542.
So, Mr. Villalobos, is your
Excuse me, ma'am.
client have? Hold on.
Um,
You have an attorney. I can't speak to you directly. Mr. Villalobos,
Yes, ma'am.
does your client have visitation with the child?
He's supposed to have visitation, Your Honor, yes.
But has it been exercised?
My understanding is lately he hasn't had the correct address.
Okay. And the visitation, is it standard, extended? What type of visitation is it supposed to be?
Standard visitation, Your Honor.
Okay. So is there a reason why Mr. Sanchez has not been able to visit with the child, Ms. Iracheta?
No, he gets her every Thursday from 6 to 8 every other weekend on his scheduled time.
Mr. Sanchez, have you been visiting with your daughter?
I actually have a couple of police reports where she's giving me trouble and I mean, by
Okay,
the
no,
time I
that's
leave-
not the question. The question is have you visited with the child?
when I can, yes.
And when you say when you can, is it because of a work schedule or because of interference?
It's usually both the interference and my work schedule too.
Ma'am, I
What
would
do
like
you
to
do?
comment.
Hold on.
Okay.
Where do you work?
I work for International Paper.
Do you work shift work?
They alternate.
And by alternate, you mean what? That you
Um,
have a certain schedule for some time and then it changes?
Yes, like this week I have 7 to 3. Next week I'm going to be I'm going to be 3 to 11, and then the following I will be a night shift. I will be 11 to 7.
So you do a 3-shift rotation then?
Correct.
Okay. And so then, when that happens, do you notify her in time?
Yes, I do notify her at like within time.
Okay, and so what days do you work? Do you work the same days, Monday through Friday? What days do you work?
I work every day, Friday, Monday to Sunday.
You work 7 days a week with no day off?
Yes, ma'am. Yesterday, I barely got today off too. I have to notify them ahead of time. And
How can you have not a day off and it not violate the labor laws?
I've also asked, they tell me that it's production. I mean, that's your answer. And
So you work 7 days a week with no days off at all?
or I have holidays, but I don't have just regular days off.
Well, okay. That's something that I think I really advise you to speak to your attorney about, especially if you're about to get into a custody battle. So Ms. Iacheta, what do you do for a living?
I work at a convenience store. I work from 5 to 12.
Every day?
I have Sundays off and Wednesdays.
Okay, and 5 a.m. or 5 p.m.?
5 p.m. to 12 a.m.
Okay, and is this a set schedule?
Yes.
And what convenience store?
Fast Track 4
Where is that located?
in San Carlos, Texas.
Okay, so you work from 5 p.m. to 12 a.m. You're off every Wednesday and Sunday.
Yes.
Do you have other children?
No, I just have her.
So the reason I'm asking you all these questions are because when we have this in-person hearing is you need to be prepared with information that like such as this that I've asked you. I'm gonna want to know, and I'm giving both of y'all a heads up because, and I normally wouldn't do this and nobody else would do this, but I'm telling you because I don't want to waste my time. I'm going to need to know from you, Ms. Iracheta, who takes care of your child when you're at, no, don't answer now. Who takes care of your child? I'm going to need to know what kind of grades your child has. I need to know where the child has been going to school. I need to know the child's attendance record. I will need to know if the child goes to the doctor. How often do they go to the doctor? How often does she go to the doctor? And Mr. Sanchez, the same thing. You know, I'm more concerned now with your job situation. I need to know if you're able to see your child. If you're able to see your child, and if you're not, why you haven't been able to see your child on certain days. And if there's interference, I want to know what type of interference. If you have police reports, make sure you get those to your attorney as soon as possible. And that goes for both of you. Make sure. Now, if you have police reports that you're planning on using Mr. Sanchez, then I just got that information from Ms. Iracheta. I would suggest that you email them to her just so that we're not wasting our time. And she has an opportunity to review those as well before we come to the hearing. So we will be coming on, when is the first Wednesday in the afternoon that we have available? A Monday or a Wednesday?
1 second, Judge.
Okay.
Judge, we have July the 25th, Your Honor, at 1:30.
Okay, I'm not available on that date.
We do.
That's when I'm gonna be out. Oh, no. We can do it that day. Oh, wait. July 25th
Yes, Your Honor.
at 1:30?
Yes, ma'am.
Oh, I can do it that day. Yeah, that's fine. So that I have contested hearings already set up. If anything cancels in time to give y'all notice, we'll move you up. If not, it'll have to be July the 25th at 1:30. However, for the record, what is the emergency that you're basing your motion on?
Your Honor, my understanding from the client and in the affidavit, it provides that the lady is the gentleman that's staying at the house or living at the house that apparently has some type of issues with drug issues. And that was essentially it. Was that correct, Mr. Sanchez?
Yes. And well, I mean, I also have evidence on Brianna too. I have screenshots where she's messaging somebody else for drugs as well.
Okay, well, you better be prepared to overcome the hearsay on those.
No, I have screenshots. I'm sorry. I have screenshots where it shows her name, her photo, and it's.
Yes, but you need to be prepared as to how did you come across those screenshots, the person that can verify those screenshots, if you're going to be asking for that to be admitted into evidence. I'm not talking to you about it. I'm speaking to Mr. Villalobos, and he knows.
Right. Yeah, so no, we'll cover the evidentiary rules, Your Honor. But essentially, that was the essence of the concern, is that drug use and drug abuse and the residents and a gentleman that goes in there and who they're addressed to. I actually know who they're addressed to, so I'm going to bring them in and testify.
Okay, so Miss Iracheta, are you still living with your partner?
No,
Okay, so who are you living with in your home?
with my mother.
Okay, so be prepared to bring your mother then that day, because I will want to hear from her. Okay,
Of course.
all right, anything else?
Yes, ma'am. I also have her grades with me.
Okay, I don't, not from you, from your attorney.
I'm sorry.
No, I just wanted to double check, Judge. I couldn't hear the email address. I heard the MUA, then I had a hard time with the next few letters.
Me too, but this is what I got. MUADEEP9@gmail.com. I would suggest you get a new email address because that's pretty disgusting. Okay, so if you read it all together, I don't know if that's how you meant or if you realize.
Oh.
Okay, read it all together and see what that looks like. Okay, so that's not cool, okay?
I'm sorry, I had that for years.
I know. If I stayed with the email I had from when I was a freshman in college, no, let's not.
Oh, I had that since high school.
Yeah.
All
Yeah,
right,
well,
Judge,
there's an
and
age
the phone
difference
number.
between you and I. When I was in high school, you probably weren't even born yet. All right, what I'm saying is just that, so that's the email address.
Yeah, I'll
Okay,
change it.
yes, ma'am. And the phone number, ma'am, was 9496, the last four numbers?
Yes.
all right.
956-908-9496.
Okay, I got it now. Thank you so much, Your Honor. Appreciate your time, ma'am.
All right, take care.
You have a wonderful day, ma'am.
You too. Thank you. Okay. Any luck yet on Miss Cedillo?
No, Judge.
Okay. Mr. Sanchez, you are excused. Mr. Ramirez, what do you have?
Good morning, Judge.
Good morning.
Yes, Judge, I have number 33 in your docket representing the defendants. It's on a DWAP docket.
I'm sorry, what number?
Number 33, 33.
Okay, 1 moment. Okay, CL 190195-I, Cascade Capital LLC, et al. Versus Epigmenio, EPIGMENIO, Torres Cerda, and Sylvia Torres. And
Your
you're
Honor,
representing the Torreses?
Yes, Your Honor. Dennis Ramirez on behalf of both defendants.
Okay, is anyone here on behalf of Cascade Capital?
Good morning, Your Honor. John Keller on behalf of Cascade Capital.
Okay, and what is the announcement, gentlemen?
Your Honor, with this case, out of the 40 some that I've been provided, this is only one of them. The only one that I have not received any instructions from my client. In abundance of caution, unless Mr. Ramirez has some additional information he'd like to enlighten us with, I just respectfully like to request to retain the case on the court's docket and set for a bench trial.
Okay, Mr. Ramirez, your response?
Judge, I'd object to the case being retained on the docket. This case has been set at least 2 or 3 times now for DWAP. I have attempted to make contact with the plaintiff's counsel to no avail. This is an extremely old debt, Your Honor, and there's been nothing to drive forward the case. I'd ask the court to dismiss it at this time.
Mr. Kettler, I don't believe you were the attorney that appeared on this case the time before. Is that the previous times? Is that correct?
That's correct, Judge.
Okay. And I had given them an opportunity the other previous times. Mr. Ramirez is correct, because they were going to reach out to Mr. Ramirez to give him, they had gone over some possible settlement, or to give him an opportunity to go over some possible settlement. So I actually accommodated your client several times and they never did anything about it. So at this time, due to their lack of cooperation or action on the case, I am going to dismiss it for want of prosecution.
Understood, Your Honor.
So if they get in touch with you before the expiration of the period, you can always file a motion to reconsider, but they haven't done anything since it started and I gave them the chance. Okay. All right. So, Mr. Ramirez, anything else?
Nothing further this morning, Judge. May I be excused?
You certainly may.
Thank you, Judge.
Okay, thank you. Okay, I have Sandra Olea. Sandra Olea.
Sí, buenos días.
Okay, Miss. Ahorita le llamo, ok. Por favor, un momento, porque la señora que me asiste con traducir está disponible ahorita, pero ahorita va a regresar.
Gracias.
Ok, de nada. All right, Alma Sanchez. Alma Sanchez.
I'm here.
All right, that's number 5 on the court's docket, CL 171415-I, Jefferson Capital Systems versus Alma Sanchez. Are you here on that one too, Mr. Kettler?
I am, Your Honor.
Okay, and what's the announcement?
Your Honor, originally, plaintiff's office was looking to get a setting for a motion for default. However, there are a couple of factors here. The first one, Ms. Sanchez has made appearance, so obviously we can't do that. And in addition to that, it appears that there is, according to the court's notes, a possible settlement here. So, Ms. Sanchez, do you have some additional information?
Yes, I made my first payment this morning.
Okay, so you've already settled with the plaintiff?
Yes.
Okay, Mr. Kettler, do you see any settlement documents, or my staff, do you all see any settlement documents?
Let me check quickly, Judge.
And Your Honor, I'm reviewing one more time. I don't show any settlement documentation that's been provided to me. However, if Ms. Sanchez, if you did recently settle the case, and they should be sending over settlement paperwork, about how long ago was it that you were able to reach a payment plan with the firm?
It was this morning, actually. I had called them in because I had received some more papers in the mail. That's how I found out I had court this morning.
Okay, understood, Ms. Sanchez. Your Honor, if it would be all right for us to get a additional DWAP setting to be able to get those dispositive documents into you, then that would be much appreciated.
I'll just give you the same tickler date. You don't have to appear on it again. It'll be June the 24th.
And I don't see a problem with that, Your Honor. And
Okay.
if by some chance they don't get the documents in before the tickler and the DWAP notice goes out, but they do get them in later, then it would be removed from the docket.
Correct. I mean, it's not gonna be the case. What it is, it's just a reminder. So if you do it, all they're gonna do is wait, check on that date. If you did it, they just remove the tickler and we don't have to call you.
Sure, Judge.
Okay. So Ms. Sanchez, of nothing further. Oh, you know what? Let me go ahead and get your email address.
It's alma_Sanchez09@yahoo.com.
Okay. All right. If nothing further, you are excused.
Thank you.
Thank you, ma'am. Okay, I have a Mitchell, Michell, Mitchell, or Michelle, or I don't know.
Michelle.
Okay, it's because the name is only up to the L.
Yeah.
What number? Do you know your number?
47, I believe.
Okay. Okay. CL 196535-I TD Auto Finance versus Michelle Garza. Is Mr. Kettler, are you here on that one, number 47?
I am, Your Honor.
Okay. So Ms. Garza is making an appearance. Ms. Garza, has anybody reached out to you as far as to do a possible settlement?
Not in a long time. This was back.
Oh. I'm sorry, ma'am, I lost your audio.
Oh, I'm sorry. Can you hear me now?
I can.
Okay. I was saying that nobody has reached out to me that I am aware of. This happened to me in 2019. I voluntarily returned the car back to the dealership because I had an accident. I went back to see if it could get fixed with warranty or even with my insurance, and it was way too much. So I voluntarily took the car back to return the car because I wasn't going to be able to pay for them to fix it. And I wasn't going to be able to continue making the payments because it was messed up.
Okay, no, I understand that. So, but are you going to want to enter into a settlement, or are you going to want to fight this matter?
I don't know where I stand. Like, I really.
Okay.
I don't know.
So do you want to hire an attorney, or are you going to continue to represent yourself?
I really can't afford an attorney because I just started working again.
Okay.
I've been working for 2 weeks and it's been hard for me financially.
Okay. Mr. Kettler, is Ms. Hale the person that Ms. Garza would need to contact?
Her contact information would still be the one I'd like to provide, Your Honor.
Okay. Ms. Garza, do you have something to write with?
I do.
Okay. And it's also in the chat. So if you want to access the chat in a little bit, you can, but let me give that to you so I can put it on the record.
Okay.
So her name is Megan, Megan. Last name is Hale, Hale. Phone number is area code 262-796-6956. 7890. Email address mhale@rsieh.com. So I'm going to give you an opportunity to contact her to see what it is that you want to do, and we'll return on this matter on August the 15th at 9:30. So I'll retain it until then.
Okay.
Okay, anything else?
Not on my end. I will contact her as soon as I can.
Okay, and Mr. Kettler, anything else?
I do have some additional cases, Your Honor, nothing further.
No, I mean on this case.
Oh, on this one, no, ma'am.
Okay, all right, then Ms. Garza, you are excused, and I'll come back to you shortly, Mr. Kettler.
Thank you, ma'am.
Okay, thank you, you too. Ms. Castañeda, Ms. Olea is Spanish speaking. Can you please ask her if she's representing herself and to unmute herself?
Señora Olea, por favor, prende su micrófono.
Bien.
¿Se va a estar representando usted sola, Ms. Olea?
Sí, pues es
Yes.
que no sé de qué se trata.
I don't know what this is about.
Okay, ask her if she happens to know what number she is on the docket.
¿No sabe qué número es usted en las orden de hoy?
Creo que el 50 y... Permítame.
She's number 56, Judge.
Okay, CL 21-1117-I, Portfolio Recovery Associates versus Sandra Olea, OLEA, de Gonzalez, GONZALES. Mr. Kettler, are you on this case?
I am, Your Honor.
Okay. And Ms. Castañeda, please let her know that this is a debt collection case.
Señora Olea, este es un caso de una deuda de colección.
Deuda, ok.
Okay.
And ask her if she's had an opportunity to review the lawsuit that was served upon her.
¿Ha tenido usted una oportunidad de mirar los documentos que la sirvieron?
Sí, sí, esta semana.
Yes, this week.
Does she recognize the person that is claiming that they have the debt against her?
¿Y usted reconoce la persona que tiene la deuda contra usted?
No, es mi pregunta aquí.
No,
¿Quién
that's
es?
my question.
Okay, hold on. Mr. Kettler, do you know who the original holder of the debt is?
Yes, Judge. This is a third-party lawsuit originally held by Community Bank, Beal's credit card.
Okay, tell her that it's a Bell's credit card.
Es una tarjeta de crédito de Bells.
And let her know that it's the likelihood is that she stopped paying on that credit card.
Y es más probable que usted dejó de pagarla.
No, yo ya la terminé de pagar.
No, I finished paying for that.
Does she have the proof?
¿Tiene usted prueba, comprobante?
Sí, del banco donde me estuvieron quitando los pagos.
Yes, from the bank where they were withdrawing the payments.
Okay, so what she needs to do, ask her if she knows how to email and scan documents in email.
¿Sabe usted cómo mandar? She's responding yes.
No, you just need to keep going. You just translate.
¿Sabe usted cómo hacer un correo electrónico?
Sí.
Yes.
Does she know how to scan an email document?
¿Y sabe cómo subir los documentos y mandarlos en un email?
Sí.
Yes.
Okay. Mr. Kettler, what I'm going to do is I'm going to give her the information for Ms. Hale and ask her to submit any proof that she claims in paying off that debt. And then we'll go ahead and come back on August the 15th at 9:30.
Understood, Judge.
Okay, let Ms. Olea know that the next appearance will be in person in our courtroom on August the 15th at 9:30.
Señora Olea, la próxima corte va a ser el día 15 de agosto a las 9:30 de la mañana y va a ser en persona.
Sí.
Yes.
Okay. And ask her if she knows how to click on the chat.
¿Sabe cómo a promover el botón para tener una conversación?
A ver,
I'm checking.
¿en chat?
Sí.
Sí.
Yes.
Ask her if she sees the name Megan Hale there.
Mira el nombre que dice Megan Hale. Dice Megan Hale y tiene un número de teléfono.
Okay, we can help her off the record. What I'm gonna do is take a quick 5-minute break. And then, Ms. Rivera, if there's anybody in the courtroom, if you'd like, you can escort them out so that you can go ahead and go run that quick errand. Okay, so we'll continue to help her off the record. So we're gonna take a quick 5-minute break. We're off the record.
Oh, pardon me, Your Honor. Would it be all right if I briefly hopped off the Zoom call to address a couple quick matters I have in another venue?
Yes, you and Ms. Cedillo is the only one that we have left. So yes.
Okay, thank you, ma'am.
Okay.
I'll be back soon.
Okay.
Yes,
Ms.
go
Olea.
ahead and give Ms. Olea the information.
Okay, hold, it's fine. Let me just, we're not on the record anyway. So Ms. Olea, no ve usted donde dice Megan Hale? Ok, está bien.
No.
¿Usted tiene algo para escribir?
Sí.
Ok. Mira, su nombre de ella es Megan Hale, que es M-E-G-A-N. Es Megan.
Megan.
El apellido Hale, H-A-L-E.
Ajá.
Ok, su número de teléfono.
Sí.
262.
Sí.
796-7890.
Sí.
Su correo electrónico es M-H-A-L-E. El arriba, at
Sí.
R S I E H.com.
Ya está.
Mira, cuando hable usted, es mejor que una persona que hable inglés esté ahí con usted, porque ellos tienen otro número de teléfono para personas que nomás hablan español.
Okay.
So, si usted tiene a alguien que habla inglés en la casa, una amiga o cualquier persona,
Sí,
que
sí.
ellos estén ahí cuando usted hable, para que esa persona le pueden dar el número de teléfono para esas personas que nomás hablan español.
Ok.
Ok.
Y ahí ya yo voy a mandar los documentos del banco donde me estuvieron quitando.
La señora le va a dar instrucciones.
Ok. Perfecto.
La otra cosa que le iba a decir es nomás acordarle que el día 15 de agosto a las 9:30 usted va a regresar en persona.
Sí.
Ok, yo sé que Ms. Castañeda ya le dijo. So va a ser ahí en la casa de corte en Edimburgo.
Ok. Una pregunta, juez. Yo estoy por hacerme una cirugía. Y pues todavía no sé.
¿Cuándo es?
La cirugía probablemente sea en este mes. Ahorita estoy en los exámenes y estudios. Pero bueno, Dios no lo quiera, ¿verdad? Todo salga bien. No tengo nada. Pues ya en 15 días estoy bien. Pero me dijo el doctor que si encuentran algo en las bolitas que me encontraron, pues me van a tener que quitar el pecho. Entonces voy a tener que estar un buen rato.
Sí.
¿Verdad? Entonces,
Mira.
¿yo puedo hablar para cambiar fecha?
Ok, primeramente Dios, todo va a salir bien.
Amén.
Usted va a ser sana, no se mortifique de eso, ¿ok?
Amén.
Pero si algo pasa, nomás llame, ¿ok? A la oficina y puede pedir por la señora Castañeda.
Castañeda,
¿ok?
sí.
Y Leticia le da otra fecha.
Okay.
¿ok? Y ella me va a informar, pero no se mortifique, todo va a estar bien, no le van a hallar cáncer, en el nombre sea Dios, ¿ok?
Amén, así es.
Okay. Bueno, entonces, buena suerte. Ya sabe el licenciado que usted va a regresar el día 15, pero si usted necesita más tiempo por la cirugía, no se mortifiquen, nomás los informa, ¿ok?
Muchas gracias, juez.
Ok. De nada, que Dios la bendiga.
Igualmente, Dios le bendiga.
Gracias.
Gracias.
Okay, so Mr. Kosofsky and Mr. Garcia, just to let you know, Ms. Cedillo did check in. She's been in a contested hearing in County Court 8. She let Ms. Rivera know that she was going to have to log in. But I don't think they were going to release her to come in person, but that she would log in. So, but she hasn't checked back in to log in. So I don't know. I know you gentlemen and Ms. Espinosa have been very patient, but I don't know what you all want to do.
Well, Judge, thank you for updating us on the matter. And
Oh, we're not on the record, just so you know. Hold on. Ms. Flores, are you back?
Yes, Judge, back and ready.
Okay, we're back on the record. Go ahead, Mr. Garcia, the response to what I just informed you about.
yeah, I'd like to thank the court. Thank you, Judge, for updating us on the matter. I understand Ms. Cedillo is tied up in another court at this juncture. Nonetheless, I would like to move forward if we can, one way or another. Mr. Kosofsky, what's your position?
Okay. Well, let me ask you. So, Mr. Kosofsky, you're local. Mr. Garcia, you're local too, right?
Mercedes, I'm from Mercedes, Judge. Thank you.
Hidalgo County, Mr. Garcia. Okay. So, Ms. Espinosa, is she local?
Yes, Your Honor.
Okay. So I don't want to proceed without the ad litem's because that's the protection that I look for. But we can do this on Wednesday in the morning in person.
This Wednesday, this week, Your Honor?
Yes.
May I have a few minutes to check the calendar?
Yes, please check your calendars.
Judge, I've got a problem with Wednesday. I've got 2 depots set here at the office. I think they might be Zoom depots, so I could probably double screen it. So I guess I could do that.
Well, I can also do Monday, the 13th in the either morning or afternoon. I can also do, if you do it on the 8th, I can do it in the morning or in the afternoon.
Oh, the afternoon is totally fine for me, Your Honor.
Okay.
Which day? Which day was that day?
Wednesday at 1:30.
Unfortunately, I'm in a mediation at 1:30, Judge.
Okay. What about on the 13th?
The 13th.
I have morning and afternoon that I can put you in.
I have a friendly suit in your court, Judge, in your honorable court at 9:30 on another matter.
Okay,
So
so do you
I'll be there.
Mr. Kosofsky, are you available?
I'll make myself available on Monday, Your Honor.
Okay, Mrs. Espinosa, can you come on Monday?
Yes.
Okay.
And
I hope
Judge, that's going to be for live though, in person.
Yes, in
Always
person.
live.
I hope Mr. Dio is available.
Well, she's gonna, yeah, I'm gonna have Miss Rivera send her a quick text right now before I release you all.
Okay.
So give me a couple of, just let her send a text out and she'll come back and let us know, okay?
Thank
So
you,
it
Judge.
would be for Monday, June 13th at 9:30, Miss Rivera.
Noted. Thank you, Your Honor.
So let's just wait to see. And what number was this again on, I'm sorry, on my docket?
I believe 65, Your Honor. Yes.
Yes. Okay, we'll see if she responds. If she doesn't, it's because they've already started back up with arguments. If not, gentlemen, we can contact you and let you know as soon as she tells us. And if for some reason she's not, we can just do a quick informal DCC to pick a date that all of y'all are good with. And it won't be long. We can even do it, I don't know, can we? We can even do it on a criminal day if you need to.
Judge, it's just a friendly suit, so it probably won't take more than 5-10 minutes tops.
I know.
I defer to
You know,
Your
we
Honor.
could also come back at 1:30 this afternoon if y'all are available.
That's
Via
fine by me,
Zoom.
Judge.
I am available this afternoon at 1:30, Judge. By Zoom.
Okay.
Via Zoom? Via Zoom?
Yes,
Judge?
it would be via Zoom. Bianca's going to check, Ms. Rivera is going to check with Ms. Cedillo all these options. And then we'll contact you all. Because she hasn't responded. So that means they already started with arguments again.
So, Your Honor, we can be excused right now, just stay on
Yes,
hold.
somebody from my office will contact y'all. We'll either come back in the afternoon or we'll do it on on Monday. And if not, but we'll get you in ASAP, okay?
Will the
Thank you,
contact
Judge.
be made via telephone, email?
Yes, somebody from my staff will contact you via telephone to make sure. And then that way, if it's this afternoon, we do have a link for this afternoon. They'll resend you the link for the afternoon.
Thank you, Judge. I'm working from home today. May I give your staff my cell number?
Yes, but don't do it on the record unless you want everybody to know, because we're on YouTube. Do you care?
Do you want me to put it on the chat?
Only to Ms. Rivera. And
Judge,
to-
Ms. Cedillo is walking
Oh,
in.
Ms. Cedillo's there. There you go.
Oh, praise the Lord.
Here she comes.
So all of that for naught. Now we go
It's
forward.
okay.
And we're all dying for your number, Roger.
am so sorry.
Saved by the bell.
Miss
Saved by
Cedillo,
it.
your daughter looks exactly like you when you're walking up. You're aging in reverse.
I'll take it, Judge. I just spent about 2 hours fighting in another courtroom, so I'm all out of
It's
fighting. We have an
advocating,
agreement now.
not fighting, advocating.
Advocating.
We can sense the adrenaline there, Miss Cedillo.
I know. Okay, so now you're switching hats. So settle down, settle down.
This is
You're
a
not here to
friendly-
fight anybody. You're not here to fight anybody, Miss Cedillo.
Friendly
All right.
suit. Friendly
Okay,
suit.
we're back on the record with number 65 on the court's docket, CL 220334-I, Anaí, ANAHI, Espinosa, ESPINOZA versus Eliseo Flores. And we are ready with the friendly suit hearing. That the record reflect that all attorneys are here, including the ad litem, Ms. Cedillo. So Ms. Espinosa, can you please raise your right hand? Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
All right, you may lower your hand. Mr. Kosowski, go ahead.
Thank you, Your Honor. Ms. Espinosa, you were in an accident along with Kevin, Kayla, and Kelly Espinosa on 9/16/21, correct?
Yes.
Okay, and these are your sister's children, correct?
Yes.
Okay, and she's passed away, correct?
Yes.
And you are their legal guardian?
Yes.
Okay, and their father is nowhere that anyone's seen for years?
No, never.
You mean that's correct?
Yes, correct.
Okay, thank you. Now, as a result of this accident, your nephew and nieces were injured, correct?
Yes,
Okay, and as a result, they received medical treatment.
correct.
Okay, and as a result of that, they have had a chance to recover, correct?
Yes.
Okay, and we filed a claim, and that's what we're here about today. And we've come to a settlement that I want to go over with you so the court's apprised of it and we can get the court's approval. You understand that?
Yes.
Okay. So for Kevin, we have an agreed settlement at this point for $23,000. That is going to be broken down. 1/3, we've reduced our fees for attorney's fees. The medicals were about $12,000 for medicals. We had a Medicaid lien. We've reduced that down to $5,362 for the medicals and $112.92 for Medicaid. We reduced our expenses from $250 down to $100, and that leaves $9,766.08 to be put in the registry of the court for Kevin, which he will not be able to touch until he's 18. You understand that?
Yes.
Okay. And I'm going to go over each before I go to the ultimate questions, okay?
Yes.
Okay. On Kayla, she has a settlement of $20,000. Similar situation where we've reduced our fees to 1/3, and her medicals were over $10,000. We've reduced them down to $3,900. And as a result, $9,340 will be put in the registry of the court until Kayla turns 18. Okay, correct?
Yes.
Okay. And for Kelly, we have a settlement of $15,000, which again, we've reduced our fees to 1/3. And she had the least medicals of all three, but still about 6,000, 7,000 in medicals, which we've reduced to 3,200. And she's got a balance of $6,705, which will be put in the registry of the court for her benefit. When she turns 18, she can pull it. You understand that?
Yes.
Okay. Now, as to all three of these claims, you understand that if we went to trial, the jury could award more, the same, less, or even nothing.
Yes.
Okay. And if the court approves this settlement, that will end all claims against all of the defendants and their insurers. You understand that their claims will be resolved at this point.
Yes.
Okay. How are they doing now? Have they fully recovered?
Yes, they are.
Okay. Do you believe that these settlements are in the best interest of your children?
Yes.
Of your yes. Okay. And they are your children. Okay. And have you been happy with the way my firm and I have dealt with you and the kids?
Yes, very pleased. Thank you.
Thank you so much. That's all I have, Your Honor.
Okay, Mr. Garcia, do you have any questions of Ms. Espinosa?
Just a couple, Your Honor. Thank you. Ms. Espinosa, thank you so much. And I understand that you are now raising your nephew and nieces. My understanding is that they were born on April 7th, 2007. Is that correct?
Correct.
So they're triplets and they're 15 years old?
Yes.
Well, and I'm sure you're doing a great job raising these children. Now, I believe you testified that they have fully recovered from the injuries they sustained in the subject accident, correct?
Correct.
One other question. Now, a few weeks ago, there was a document that was sent to your attorney, and it was called the Settlement Agreement and Release that needed to be executed and notarized. That was done and it was returned. Do you understand that by executing that release, that concludes the matter and there will no longer be any claims that can be filed or any other funds that can be requested or demanded from this particular accident regarding your nephew and nieces? Are you aware of that?
Yes.
Your Honor, that's all I have. Thank you, Judge.
Okay, Ms. Cedillo?
Yes, Mrs. Espinosa, good morning.
Good morning.
And sorry to keep you waiting. I know you've been waiting as well as the attorneys. They're getting paid, and so I apologize for keeping you waiting, Mrs. Espinosa.
And that's okay. I'm getting paid too, and so is my staff. We're all just here. That's okay. Go ahead.
Espinosa, you had an opportunity to visit with me, is that correct?
Correct.
And bring the children by to visit with me?
Yes.
Okay. I don't know if I asked you this that day, but do you have legal documentation for your nieces and nephews?
No.
Do you have anything that makes you a guardian for them?
I have an affidavit from when she passed.
Okay.
From 2017.
Okay. And aside from that, you understood what the settlement offer was going to be, and we had an opportunity to go through those numbers one by one. Is that correct?
Correct.
And those are the same numbers that were read into the record this morning?
Yes.
And that is your agreement, is that correct?
Correct.
And you understand that you have the option of choosing that this case goes to trial?
Yes.
And that would be decided from a jury to determine what amount of damages they believe the children would be entitled to. Do you understand that?
Yes.
Okay. And do you understand that a jury could award more than is being awarded to you by settlement, could award the same, or could award less?
Yes, I'm aware.
And knowing that, you opted to reach a settlement to these numbers. Is that correct?
Correct.
Now, and you understand that the settlement is just as to the children, not anything that you may recover as a result of the accident?
Yes.
Okay. And that money would be deposited until their children reach an adult age where they can go in and try to withdraw that. Is that correct?
Yes, correct.
And knowing and understanding all that, are you still wanting to go forward with this settlement?
Yes.
Okay. Judge, and I don't mean to create any problems with this settlement. The only issue that I see that I was not aware was whether Ms. Espinosa has standing to litigate for the children and thereby recover for the children, sign any legal documentation on behalf of the children. That would be my only reservation. Aside from that, I do believe that it's in the best interest of the children.
Okay, so is, because no one is contesting it and there wasn't any kind of affirmative defense issued on that issue, I'm going to approve the agreement as it was testified to and put on the record. There was already an agreement that was circulated?
A settlement agreement release, Judge, was executed by Ms. Espinosa back in May. Yes.
Okay, and were checks already issued and made?
Checks were issued, and I believe they are in Mr. Krasowski's office. We have circulated the agreed final judgment. Ms. Cedillo and I discussed the ad litem fee that was also included in said judgment.
Okay.
It is ready to be filed.
And we do have the checks, Your Honor.
Okay, and so everything is going to go into the registry?
All the funds as we dictated is going in, other than the, medical fees and attorney fees that are all set out in a settlement statement.
Okay, and so, and the kiddos are 15 right now, right?
Yes, yes, Your Honor.
Okay, so will they be entering their sophomore year or their junior year?
Sophomore.
Okay. So what I will tell you, Ms. Cedillo can go into it a little bit more because it has to do with the children if you have any questions and if you want to, but all I was gonna say is just like, look, they're twins. So if you do have some expenses that come up during their like senior year or something like that, right before they're actually going to get that money, and if you do need like an early withdrawal or something, speak to somebody about asking the court for that, because I certainly know that children are expensive. And I certainly know, especially the senior year is expensive. And so now are the twins boys or girls?
Triplets, 2 girls, 1 boy.
Triplets, even more so. Okay. Well, I also want to extend my condolences to you and to your nephew and your nieces. And I commend you for stepping up, because it's not easy to take over. Do you have your own children as well?
No.
So you're, and so right now being their source at such a tender age is very important. So I commend you. So I'm also taking judicial notice of all the documents in the court's file as well. So I'll sign that as soon as it comes to me. And Ms. Espinosa, like I tell everyone else, my staff and myself, we're always here to serve the community. Okay, so I wish you the best of luck. May God bless you. And I pray that everything goes well with your kiddos.
Thank you.
Okay, you take care. Thank you, gentlemen, for being patient. Ms. Cedillo, thank you as well for being patient, because although you were the one advocating over there, I'm sure you were anxious to get over here and get this done. So don't worry about it. I know how it goes.
And Ms. Cedillo, just really quick, it's off the record. I did advise the court about Cesar Aguilar's situation, so that was taken off the docket.
Wonderful. Thank you. I appreciate that. Judge, I have one question with regards to the deposit in the registry. It's happened to me before where that deposit never makes it to the registry. And I just want to I want to ask the court to maybe set a status or something where I can report back that in fact was deposited, and never with Mr. Krasowski. I'm not saying that it was.
Yes, and you know what? I have a case still from when I was practicing that's happened, and there's something in limbo. So I'll just set a tickler for June the 24th, and if it hasn't been submitted by then, but that's a good idea. We should probably get into the practice of doing that as well, just to check up on it. So we'll just check it up on June 24th to see that it's been submitted to the registry, and if not, then we'll just do a show cause.
Thank you, Judge. Having no.
Your Honor, will I have to appear since the checks have
No,
already been-
ticklers are just reminders for the court, and they're my staff. They take care of the ticklers.
Okay,
Judge, I think that's a great idea. In this particular case, we have the checks already. So I'll send out an email to everyone letting them know once the deposit's been made, which will probably be, today, tomorrow, quickly. But I think that is a great idea, because sometimes they don't come right away.
Okay. And
Not
also,
for
no, I know. And he's
not
not the one
yet.
that has, and the attorney is never the one that has the control. I mean, it's always with the adjusters and the company and stuff. So, but let me also, just on a side topic, it has nothing to do with this, but just so that you all know in for your future cases, since, you all do a lot of PI work. So, I've already been on the bench going on 18 months. As you can see, I'm very unconventional. I'm not like anybody else, because I'm just like that. And there's no way, this is my courtroom and we run it the way that I want. But before you all issue all of those settlement documents and the checks, because I know I've already done it to Mr. Garcia before, you might want to check with me. I mean, maybe you should set something before, because I have always been of the mindset that since that money is for the children and the benefit, I'm not going to be opposed to putting aside some of that money to give them up front, like whether it's for clothes, whether it's for summer vacation, whether it's for the laptops, whether it's for, honestly, guys, because it's nobody has to tell any one of us how much things have already increased in price. And we are very blessed to not be in that situation, to be able to provide for our children and grandchildren and nieces and nephews, or whatever the situation may be for us. But not everyone is in that same situation. So I'm very open-minded, and I'm very thinking outside of the box all the time, because I do not feel that every situation conforms to the same set of rules or standard of practice. I know what's been customary. I've been in your shoes, in all three of your shoes. Not really defense as much, but it's happened, but I've been in all of your shoes. So I know what it is to have that client asking, can I get the tennis shoes? Can I get the jeans? Can I get them clothes? Can I do this? Can I do that? And whatever. And so just so you all know, I'm totally okay with thinking about that. If you need direction before you all cut those checks, because I know it's a pain to get those checks reissued. I know it's a pain to recirculate those settlement documents. Do not hesitate to contact us. If you need a quick status, if you need to come into chambers, even if you're here, if both attorneys happen to be there now that we're back in person, and you both want to talk about the case real quick and come into chambers and say, hey, Judge, we have this already. We're ready to do the documents, but we know how you are. You always, so can you do this? Can we do this? Can we do that? Whatever. Let's talk. As long as both sides and and you can get it approved through the ad litem, I am more than willing, because the way I see it, it's their money and it's for their benefit. So as long as it benefits the child, I mean, maybe they can't get all of it, because it's also for them to take on to a post high school, right? After they turn 18 and get started or whatever. But what I'm saying is, I'm very willing to look at things, just so you all know, okay?
Thank you, Judge. And I understand the court's concern in making certain that the next friend is having the resources necessary to benefit the child's best interest, and that's completely understood. The caveat is that I want to make certain that the plaintiff attorney has the checks in hand, but if the court is going to want to disperse checks differently, fortunately, the carrier that I'm representing has no issue stop paying on those particular checks. And however the court orders the checks to be dispersed, we can get to them. We can get them to the plaintiff attorney within 5 to 7, at the most 10 days. So I understand the plight, and hopefully we can work towards that end. And I thank you.
Okay, no problem. And Mr. Kosovsky, I mean, I don't know if you want to say anything or.
No, I appreciate that, Judge, because that I get that so often from clients where they need just what you're talking about. And I have to tell them it's not up to me, and it hurts. And I know it's not up to me. I mean, obviously, but sometimes you don't get that compassion, and I'm not naming any names or anything like that, but it's wonderful to hear from you. And again, Roger's I love dealing with Roger. If he says he can get in a couple of days, he will, and
yes,
he's a pleasure.
I love dealing with Roger too. So
thank you, Judge.
All right, and with Mr. Kosovsky as well. And it's all right. So Ms. Edna, thank you so much. And your fee has already been agreed to, correct?
That's correct, Judge. Thank you.
Okay. All right. Anything else?
That's all I have before your honorable court. May I be excused, Judge?
Yes.
Thank you. Y'all have a wonderful day.
Thank
Take
you.
care.
Likewise, Mrs.
Edna, good seeing you again.
Take care.
Thank you, Judge.
Okay. Ms. Castañeda, you're not getting extra points for having a cute puppy on there.
Judge, she won't get off my lap.
All right, Mr. Kettler, we're good. You want to go one by one on your cases?
Yes, Your Honor, that would be great. And I've had a chance to review them extensively, and I believe these have some similar issues for the most part. So I'm happy to start up and down the
You're
docket.
like, I better look at these things because I already know what that lady's going to ask.
and also the general local rules with Hidalgo. With I understood there was some issues with order setting hearing not going
Yes.
out in
Or
previous
like
cases.
like one of my friends says, rule schmools. You know? Okay, no problem. Let's go one by one.
Yes, ma'am.
Go ahead.
Number 6, Discover Bank versus Campos.
CL 172053-I, Discover Bank versus Maria Luisa Campos. Maria Luisa Campos. Maria Luisa Campos. Okay, the name being called out 3 times. No response. What is the announcement?
Your Honor, with this one, plaintiff's office has filed a motion for default judgment, is respectfully requesting to retain the case in order for an opportunity for it to be heard.
Okay, has the order setting hearing on the default judgment been filed?
I show a registry note on 6/1/22. I have not been provided that by the principal firm, unfortunately.
Okay, Ms. Rivera, do you see an order setting hearing?
Judge, on the motion for default judgment, correct?
Yes, ma'am.
Judge, we would need an order resetting. The reason why it was set for this DWAP setting was because on February 23rd, there was a motion for default, but there was no announcement. So there is a previous order reset, order setting hearing, but not to reset it, Your Honor.
Okay, go ahead and file an order resetting hearing and we'll get that file, we'll get that set for you.
Yes, Your Honor. Date TBD, or would it be that August 15th date?
No, we'll determine if we still have room on that date, it will be, but it depends how many cases you have.
For sure. For sure,
Okay.
Judge.
All right, so we'll go ahead and do that and make sure that the defendant is CC'd on that.
Yes, ma'am.
Okay, your next case?
Okay, number 7, TD Bank in Lara.
Okay, CL 173090-I, TD Bank versus Juan M. Lara, Lara, and what is the announcement?
And Your Honor, for this one, I've been made aware of a tentative settlement on this case. And plaintiff's firm is respectfully requesting an additional $60 for the DWAP to have those documents finalized.
Okay, we'll go ahead and set a status for August the 15th at 9:30. And if the settlement documents are submitted before then, we'll go ahead and take it off the docket.
And the
All right,
next
our
one,
next case?
yes, ma'am. Number 8, LV Envy and Jesus Gonzalez.
CL 173710-I, Jesus Gonzalez. Jesus Gonzalez, Jesus Gonzalez. Okay, name being called out 3 times, no response. What is your announcement?
And for this one, Your Honor, I understand a similar situation as the previous case, or excuse me, not the previous case, but the first one.
As far as it needing an order resetting hearing?
Yes,
Okay.
for a order setting for default hearing.
Okay, go ahead and file an order setting hearing on your default judgment. And we'll get that set. Okay, your next one.
And then number 9, Capital One and Leticia Luerera.
Okay, CL 174050-I, Capital One versus Leticia Luera, Luera. And what is the announcement? Leticia Luera. It's been called out 3 times.
And with this one, plaintiff's firm should have filed a motion for default and is respectfully requesting to have it heard.
Okay, did they file? So they filed the motion for default judgment?
Yes, it should be filed. Let me go ahead and double check the registry. I do show a record of them having filed it on my end, but if it's not with y'all, then
it doesn't count?
Yes, ma'am, absolutely.
Okay, I'll go ahead and see. Ms. Rivera, I'm sorry. Do you show that the default judgment, the motion was filed?
Judge, it's going to be the same announcement as the previous. It was originally set on the 23rd of February. No announcement was made, so therefore an order resetting would be needed.
Okay, So go ahead and submit an order resetting hearing. It's that a lot of these cases were set on February the 20 something and no one showed up from these plaintiffs. So that's why I had to set it for a drop to make sure somebody showed up. So, all right, your next case?
The next case I've got, Judge, is Discover Bank and Juan Ordaz Jr.
Number 10 on the court's docket, CL 174200-I, Discover Bank versus Juan Ordaz Jr. Juan Ordaz Jr. Juan Ordaz Jr. Okay, go ahead.
And same thing for this one, Judge. A motion for default's been filed. Plaintiff's firm is requesting it to be heard, and but same situation. The 23rd came, 23rd went, and here we are today.
Okay. Order resetting hearing to be filed on the default judgment. Okay, your next case?
Next case, Your Honor, is going to be Con Appliances versus Pedro R. Guerrero, aka just Guerrero.
Okay, CL 174293-I, Cons versus Pedro Guerrero. Pedro Guerrero. Go ahead.
And for this one, Your Honor, we're looking to retain for being heard on a motion for default.
Okay, submit your order resetting hearing, please. Your next case?
TD Auto Finance, formerly known as Chrysler Financial versus Juan Antonio Perez.
That's number 12 on the court's docket, CL 174396-I, Juan Antonio Perez, Juan Antonio Perez, Juan Antonio Perez. Is it the same announcement?
Yes, Your Honor, respectfully requesting to retain for hearing on default.
Okay. And then your next case?
It's going to be Con Appliances, Inc. Versus Rosa Canta.
Number 13 on the court's docket, CL 174456-I, Cons versus Rosa Canta. Rosa Canta, that's CANTA. Is it the same announcement?
One moment, Judge. Let me double check to be sure nothing, the last second, come in on this one. And I'm showing the same announcement, Your Honor.
Okay. And then your next case?
Con Appliances versus Horacio Garcia Jr.
Okay, CL 174585-I, Con Appliances versus Horacio Garcia Jr., Horacio Garcia Jr., Horacio Garcia Jr. Go ahead.
And same announcement to the best of my knowledge, Judge, just looking to retain for the default to be heard.
Okay, and then your next one?
And Jefferson Capital Systems versus Roberto Hurtado Sr.
CL 174600-I, number 15 on the court's docket, Jefferson Capital versus Roberto Hurtado Sr. Roberto Hurtado Sr. Roberto Hurtado Sr. Hurtado, okay?
And I've been instructed, same announcement, Your Honor.
Okay, next.
Con Appliances, Inc. versus Gabriela S. Benavides.
Number 16 on the court's docket, CL 174640-I, Cons versus Gabriela Benavides, Benavides, Gabriela Benavides, okay?
And same for this one, Your Honor, respectfully requesting to retain to have the default heard.
Okay, your next case?
We've got Con Appliances, Inc. versus Esmeralda M. de Amaya.
CL 174912-I, Cons Appliances versus Esmeralda de Amaya, Esmeralda de Amaya. Go ahead.
And same with this one, Your Honor, respectfully requesting to retain for default hearing.
Okay. So I was thinking right now, how could we go faster? So how many other ones on the docket are the same announcement? Can you give me the numbers?
Yes, Your Honor. So we've got, we're down to number 17. I'm double checking for Duarte, Bazaldua, Pada Guevara, Garza, Rios, San Roman, Alvarez, De La Cruz Moya, Maria De La Cruz Moya times 2. Although actually both of those appear to be the exact same setting. Then we've got Adrian Villarreal, Quintanilla, Con Appliances in Guerrero, Portfolio in Paris, Crown in Hernandez, Security Credits.
Go ahead,
Security-
Ms. Rivera, what?
Judge, Lisa, our court reporter has having some issues with her computer froze, Your Honor.
Okay. Well, while she's getting the computer rebooted, the court reporter, this is off the record. Go ahead, what other number?
Yes, Judge. Starting again at number 32, Security Credit Services and Juan Sanchez.
Okay,
Cascade Capital in, excuse me, not Cascade. We've already done that one. We've got Portfolio in Garcia.
okay,
Cascade in Lechuga.
okay,
Portfolio in Gonzalez.
okay,
Velocity in Zapata.
okay, Gonzalez was twice. Let me see. Oh no, it was 3 times. Okay, so Jaime Zapata,
Yes, ma'am.
okay?
And then Portfolio in Gallegos.
Mm-hmm,
TD Auto in Uriegas.
Number 41, Judge, she's here in person.
okay. Okay, go on.
And Con Appliances in Pruneda, number 43.
Number 43, Your Honor, there was a non-suit on file.
Okay. Okay, next.
Velocity in Alfaro.
Okay,
On Alfaro, Judge, there was no notice to the defendant, Judge. If we can reset to August the 29th.
okay,
And Miss Garza and TD Auto, we've done. And second round sub in Gloria Saldivar.
okay,
Velocity Investments in Sosa.
okay,
Portfolio in Gonzalez.
okay,
Portfolio in Bravo.
okay,
Portfolio in Munguia.
okay,
TD Bank in Carrasco.
okay,
We've done number 56. Portfolio in Cardona.
okay,
Double checking, Your Honor, to see if I have any missing. It looks like most of them are blocked together. And there was a default hearing of Portfolio in Segura, but looks like an order granting motion to withdraw the default's been filed.
Oh, on number 70?
Yes, ma'am.
Okay, so motion to withdraw the default judgment, okay?
And I'm skimming through the list one more time, but that appears to have all of my cases covered here.
Okay, I'll wait for Ms. Flores to have her reset. She hasn't tried to get back on. So we'll take a brief recess until you see her name back on here.
Sounds good, Your Honor.
Okay, thank you. Ms. Flores, are you up and going again?
Yes, I'm ready.
Perfect. Okay, Mr. Kettler, can you hear me?
I can, Your Honor. I would like to make a correction to just one. It's going to be CL 17-5048 I Duarte. And for this one, we do show an answer being filed. And for that one, that we're respectfully requesting a bench trial setting to retain.
Okay, why don't you go ahead and file an order setting bench trial? And we'll get that signed and sent in. Okay, so we're ready? All right.
Yes,
So I'm going to call out the names of each of the remaining your cases of the defendants 3 times. Since you have the same announcement on all of them, I'll just ask you to make that it's the same announcement and that you'll be filing order resetting hearings on the default judgments. Okay. So Aurelia, A-U-R-E-L-I-A, Basaldua, B-A-Z-A-L-D-U-A, Aurelia Basaldua, Aurelia Basaldua. Paola Guevara, that's P-A-O-L-A, G-U-E-V-A-R-A, Paola Guevara, Paola Guevara. Jorge Garza, Jorge Garza, Jorge Garza. Jesus Rios, Jesus Rios, Jesus Rios. Ashley San Roman, Ashley San Roman, Ashley San Roman. Brianna Alvarez, Brianna, B-R-I-A-N-A, Alvarez, Brianna Alvarez. María de la Cruz Moya, María de la Cruz Moya, María de la Cruz Moya. Adrián Villarreal, Adrián Villarreal, Adrián Villarreal. Carlos Quintanilla, Carlos Quintanilla, Carlos Quintanilla. Diana Guerrero, Diana Guerrero, Diana Guerrero. Daniel Pais, P-A-L-L-A-I-S, Daniel Pais, Daniel Pais. Fabian Hernandez, Fabian Hernandez, Fabian Hernandez. Juan Sánchez, Juan Sánchez, Juan Sánchez. Adriana García, Adriana García, Adriana García. Daniel Lechuga, L-E-C-H-U-G-A. Daniel Lechuga, Daniel Lechuga. Jose Gonzalez, G-O-N-Z-A-L-E-Z. Jose Gonzalez, Jose Gonzalez. Jaime Zapata, Jaime Zapata, Jaime Zapata. Reina Gallegos, Reina Gallegos, Reina Gallegos. Let me see. Gloria Saldivar, Gloria Saldivar, Gloria Saldivar. We're now on number 51. Marta Sosa, Marta Sosa, Marta Sosa. Ofira Gonzalez, Ofira Gonzalez, Ofira Gonzalez. Juan Bravo, Juan Bravo, Juan Bravo. Kimberly Munguia, Kimberly Munguia, Kimberly Munguia. Mark Anthony Carrasco, Mark Carrasco, Mark Carrasco. Enrique Cardona, Enrique Cardona, Enrique Cardona. I believe those are all the ones that I have. Is that correct, Mr. Kettler?
I believe so, Your Honor.
Okay, and what is your announcement on each of those cases?
Your Honor, my announcement on the above listed cases is we're respectfully requesting to have them retained on the docket for a motion for default hearing. And my understanding is that the court is expecting orders resetting hearing for all the above.
Yes. Order resetting hearings for default judgments on all the cases that have been called out previously. All those order resetting hearings need to be submitted by June the 24th. And we will give you a new date for that so that it can go out. Make sure, please, that the defendant is properly copied on those order resettings.
Understood, Your Honor.
Okay, anything else?
Nothing further today, Your Honor. I believe that takes care of my entire docket.
Okay, and mine too, apparently. Just make sure that it says in person.
In person, and
Yes.
we'll go ahead and go to that on the order setting.
Okay, Ms. Rivera, you had something?
Yes, Judge, we do have Miss Uriegas here.
Okay. I'm gonna go ahead and go back to recall number 41.
Miss Uriegas? She's Spanish speaking, Your Honor.
Okay, CL 192879-I TD Auto Finance versus Juanita Uriegas. Ms. Castañeda, please ask her if she can hear us.
¿Nos escucha, señora Uriegas?
Ande, sí.
Yes.
Okay, Mr. Kettler, she's making a personal appearance on this. What are you showing?
This one, Your Honor, we're showing same situation as before, but not for the February date. Looks like it was a little bit further back in December. Since Ms. Uriegas is making appearance today, obviously we can't move forward on the motion for default. So I just respectfully request to retain.
Okay, so Ms. Castañeda, can you please ask Ms. Uriegas if she plans on representing herself?
Señora Uriegas, ¿usted se va a representar usted sola?
Sí.
Yes.
Does she want an opportunity to contact them so that she can try to come up with an agreement?
¿Quiere usted una oportunidad para comunicarse con ellos para tratar de llegar a un arreglo?
¿Con quién?
With who?
With the person, with the plaintiff who's suing her.
Con la compañía que la está demandando.
Es que la otra vez traté de hablar con ellos y ellos dijeron que esperara que viniera aquí.
Last time I tried to speak to them, they told me to come here.
Okay. Mr. Kettler, do you still want her to contact Ms. Hale, or who else does she need to contact?
Your Honor, I can provide Ms. Hale's phone number again. To the best of my knowledge, Ms. Hale does not speak Spanish, but I also understand that that firm has a couple Spanish-speaking resolution specialists that might be able to speak with Ms. Uriegas. So I could provide her, just to be safe, Ms. Hale's phone number and an additional settlement line.
Okay, so what we'll do is, since you have it on the chat, I'll ask Ms. Rivera to just write it on a sticky for her and give it to her. And then we'll explain, Ms. Castañeda, let her know that Ms. Rivera will give her the name, phone number, and email of the person to contact, number one. And number two, ask her please to notify them that if they can give her the Spanish speaking line.
Ok, la señora Tiara Rivera le va a dar el número de teléfono de con quién se tiene que comunicar. Cuando se comunique con ellos, les pide por favor a hablar con un representante que habla español.
Está bien.
That's fine.
¿Puede hacer una pregunta?
Can I do a question?
Yes.
Sí.
Es que yo sí firmé la troca para mi hija. Y yo
I did sign the truck for my daughter.
Pero ella nomás lo usó 3 meses y dio
She
los
used it
pagos.
3 months.
Y luego para decir 4 ella la entregó.
At the start of 4th month, she turned it in.
Y ahora en noviembre 5 a mi hija me la mataron.
On November 5th, my daughter was killed.
Y el día 5, pero después recibí la carta después en noviembre, después que la mataron recibí la carta. Y por eso
After she was killed, I received the letter to come in.
Y como viene a mi nombre, por eso vine, verán.
And since it's under my name, that's why I came.
Sí, pero yo no sé mucho inglés, ella sí sabía, verá.
I don't know English, she did.
Okay, please extend my condolences to her for the loss of her daughter.
La juez le manda sus condolencias por la muerte de su hija.
And just let her know that I feel for her very much.
La corte lo siente bastante, lo siente por usted.
But she, unfortunately, because she co-signed or she signed it and it's under her name, she does need to speak to them and see if any arrangements, if any, can be made.
Pero desafortunadamente porque usted firmó por ella, por favor hable con ellos a ver si pueden llegar a algún arreglo.
Está bien.
That's fine.
Okay, so I'm going to set this status out. What is the first Wednesday in September? I think it's the 7th, correct?
That's correct, Judge.
Okay, tell her that if they haven't resolved anything, then they'll need to come back on September 7th at 9:30 to the same place.
Ok, si no han resuelto nada, señora, entonces tiene que regresar a este mismo lugar el día 7 de septiembre a las 9:30.
Gracias.
Thank you.
Okay. All right, so Mr. Kettler, we'll go ahead and just wait for those orders resetting hearings to be submitted.
Understood, Your Honor.
Okay, and you did not have number 3, correct?
With number 3, let me go ahead and double check. I show an order of non-suit on that one. I thought it was a little strange that I didn't show it on my docket. And I'm not sure who the attorney of record would be. It might be an old rash term case.
Do you show, is there a non-suit on file with the court?
That's the only non-suit that is on file is for Mr. Javier Loya. One of the defendants, Ms. Ruby Martinez, remains.
Okay.
And Your Honor, I do see that the clerk's office received a phone call on the 18th of April, and it was from Miss Ruby Martinez's sister, this as a Miss Perez, advising that Miss Martinez had passed away several months ago, and that she'd be sending a letter to the court of her sister, addressing her sister's passing.
Okay. Very sad. Okay. All right. Okay, Mr. Kettler, if nothing else, I do have a couple of other cases, not yours.
All right, I believe that should take care of all my debt claims, Your Honor.
Okay, thank you. You have a good day.
Thank you, y'all too.
Judge, in person, we have Ms. Ocañas.
No relation.
No relation, Judge, and it is number
63.
Yes, ma'am.
Okay, bring her in.
She is Spanish speaking as well, Judge.
Okay.
And I believe this was in regards to a name change, Your Honor.
Okay, I think we were missing some documents. Is that correct?
I can check quickly. 1 second.
Okay.
This judge, the petitioner was to send her fingerprints to Austin, Your Honor.
Mm-hmm.
And I don't see anything returned. Actually,
Okay.
1 second. Let me just confirm it. Judge, it was sent to it is on file, Your Honor. And it is directly from Austin.
Okay. And everything was good?
It seems that it is, Your Honor. Yes, ma'am. That's correct.
Okay, go ahead and bring her in.
The only thing pending, Judge, would be the order.
Oh, okay. Okay, Ms. Castañeda, ask her that if she can raise her right hand.
Por favor, levante su mano derecha.
Does she swear to tell the truth, the whole truth, and nothing but the truth?
Jura que el testimonio que está a punto de dar es la verdad, toda la verdad y nada más que la verdad.
Sí. Okay. Let her know that the last thing that was pending was the fingerprints. And did she already do that?
Lo único que faltaba era la verificación de las huellas y ya lo hizo.
Yeah.
Yes.
Okay. And okay, I really do not, this is a sidebar. I really do not know what is going on with my passwords. I had to change them all while we were on, and that's after Bianca had already changed them for me. So now after I wrote them down, I can't get back into my computer. So hold on.
Es sobre nada de eso.
Ah,
I'm gonna have to rely on. I'm getting a message. Hold on real quick. I need to send it to IT. Okay, so what I'm going to, let me go ahead. The only thing that I was missing was that, and do you recall or do you have notations there that we already proved up the petition?
That's the last thing that we had, Your Honor, was that there was no appearance.
Okay, all right. So tell her to state her, ask her to please state her current name.
Por favor, diga su nombre que tiene ahorita.
Milila Silva de Ocañas.
Milena Silva de Ocañas.
And that's Milila, and then Silva, Silva, de Ocañas, Ocanas. And just for the record, there is no relation between myself and Miss de Ocañas. Okay. So for her to please state, why is it that she is seeking a name change?
Por favor, diga por qué está pidiendo el nombre, el cambio de nombre.
Porque íbamos a tramitar la licencia para casarme y me querían poner solo el apellido Ocañas, que viene siendo el de mi ex esposo. Entonces yo quiero tener el apellido Silva, que es el de mi papá.
Okay, we were transmitting an application for marriage, but I want to have Silva, which is my dad's last name.
Okay. Is she asking for a name change to avoid any criminal prosecution?
¿Está usted pidiendo el cambio de nombre para prevenir alguna persecución criminal?
No.
No.
Has she ever been convicted of a felony?
¿La han convictado de una felonía?
No.
No.
Okay. And just for the record, Ms. Rivera, after reading the criminal history on her submitted by the state of Texas, does it show that she has a clear criminal history?
Yes, ma'am.
Okay. So let the record reflect that Ms. de Ocañas is requesting a name change to Milila Silva to return to her maiden name after her divorce, and that her fingerprints have come in, and that it shows that she does not have a criminal history. Therefore, I am granting her name change and to Milila Silva. Just let her know I'm granting the name change.
Le estoy otorgando el cambio de nombre.
However, she still needs to file an order to that effect.
There is an order on file, Judge.
Oh, there is? Okay. Go ahead and forward that order and we'll get that signed. All right. Bueno, felicidades. Okay. Let her know that when we get it, it'll get emailed to her at the email address that she had submitted.
Cuando después de que se firme, se le va a mandar a la correo electrónico que usted puso.
Muy bien, gracias.
Thank you.
Okay.
Listo. Gracias.
Okay. All right. Let me call out the ones that are left. So I have number 2, CL 144275-I, Maria Marta Montoya versus Marta Isela Montoya. Marta Isela Montoya, Marta Isela Montoya, Maria Marta Montoya, Maria Marta Montoya, Maria Marta Montoya. All names being called out 3 times, no response. This case is dismissed for want of prosecution. On CL 162605-I, state of Texas. I'm on criminal tomorrow already. Number 3 on the court's docket, Cascade Capital versus Javier Loya and Ruby Martinez. Let the record reflect that a non-suit was filed on Javier Loya. And also let the record reflect that a relative of Ms. Martinez did call into the clerk's office advising that she had passed away. And therefore, the dismissal for want of prosecution is granted. Number 42 on the court's docket, CL 193689-I, Pink Realty LLC versus MK Contractors et al. Pink Realty, MK Contractors, DBA The Limo Club, Francisco Davila, Miguel Silva. MK Contractors LLC, DBA The Limo Club, Francisco Davila, Miguel Silva. No response to any of the parties that were called.
Judge.
Yes.
I apologize, Judge, on number 42, which is the case that you called.
Yes.
44, 45, and 46. Those are going to be reset to August the 29th, Your Honor. I apologize.
So 42, 44, 45, and 46 did not receive notice?
That's correct, Your Honor.
Okay. Number 49, CL 200651-I. Was notice sent on this one?
Notice was sent, Your Honor.
Okay, Abraham Solis, Nancy Villarreal. Abraham Solis, Nancy Villarreal. Abraham Solis, Nancy Villarreal. Jose Sanchez, Jose Dominguez, Juan Hernandez. Jose Sanchez, Jose Dominguez, Juan Hernandez. Jose Sanchez, Jose Dominguez, and Juan Hernandez. Names being called out 3 times, no response. This will be dismissed for want of prosecution. What about on number 60?
Notice was sent, Your Honor.
Okay. F 3121-15-9, in the matter of the marriage of Luis Enrique Acosta and Sarabiel, Sarabiel, Velez, Velez, Marcial, Marcial. Luis Enrique Acosta, Sarabiel Marcial, Luis Acosta, Sarabiel Marcial. Name being called out 3 times, no response. That will be dismissed for want of prosecution. Number 74, CL 221240-I. Rosabel Munoz, Sandro Puente versus Brandon Vergara. Any appearances?
Your Honor, this motion was granted administratively, Your Honor, and reviewing it in the queue.
Okay. And number 76. F 4816-16-9, in the interest of Angelina Pruneda, Daniel Pruneda, and Diana Danielle Pruneda. Any announcements from any of the parties?
Judge, they filed a Rule 11 passing the status hearing, but there is no order resetting, Your Honor.
Okay, please notify them that an order resetting hearing needs to be done before this Friday, or else they will be placed on a drop docket.
Yes, ma'am.
The Friday is the 10th, correct? Okay. All right, that concludes this morning's docket. We are now off the record.